Hey, guys, I don't know if you read it, but June 25th to July 16th, The Tempest, Prince George's Shakespeare in the Parks. In the
Yes.
park.
Yeah,
Which
some of
part?
that.
What part?
It's different ones. It goes, let's see, Fairwood Community, Patuxent, National Harbor Plaza Stage. That's on June 30th. That should be interesting. Fort
Yeah.
Washington Park. They're all listed.
Right.
Nice. All right. We'll get educated.
And so we can
Okay.
get our 7th award.
I think we are ready to begin. 10 o'clock, yes. Okay. Good morning, everybody. The time is 10 o'clock. I call the May 4th, 2023 Planning Board meeting to order. We are joined by Vice Chair Bailey,
Good morning.
Commissioner Washington,
Good morning.
Commissioner Dorner,
Hello.
and Commissioner Geraldo.
Good morning.
And I am Vice Chair, I'm Chair, I'm sorry, I just demoted myself. I am Chair Shapiro. Please note that for all participant pre-registration and for all submission of materials and exhibits was, the submission deadline was 12 noon on the Tuesday before this planning board meeting. Registered speakers may join the meeting with a link provided in the email provided by the planning board office or listen by phone by utilizing the call-in number provided in the email. And of course, anyone may tune in to watch the planning board meeting via live stream. If you wish to speak or become a person of record, you may use our online web form, which you'll see referenced on the screen for you. In addition to the commissioners, we are joined by our principal counsel, David Warner, our planning board administrator, Jessica Jones, our senior technical hearing writer, Joe Parsons, James Hunt, who is the division chief of the Development Review Division, and we have staff members Kenneth Flanagan and Ryan Crowder helping us with technology behind the scenes. Thanks to everybody. So first item is I would look for a motion to approve the draft minutes of April 27th, 2023.
Motion to approve draft minutes.
Second.
Got a motion by Vice Chair Bailey, a second by Commissioner Washington. Any discussion on the motion? No discussion. I'll call the roll. Vice Chair Bailey.
Good eye.
Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Geraldo.
I vote aye.
I vote aye as well. The ayes have it 5-0. Next is our consent agenda. We only have one item on the consent agenda. Does any board member or anyone else wish to discuss any of these items? If not, I'd look for a motion to approve the consent agenda.
Motion to approve consent agenda items number 4A in accordance with the recommendation of staff.
Second.
Got a motion by Vice Chair Bailey, a second by Commissioner Washington. Discussion? Seeing none, I'll call the roll. Vice Chair Bailey.
Good eye.
Commissioner Washington.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Geraldo.
I vote aye.
I vote aye as well. The ayes have it 5-0. Now we'll move on to our regular agenda items. First is item 5. This is a DSP detailed site plan, DSP 86116-15 Waterside Subdivision Hill Residence. This is continued from the March 23rd, 2023 Planning Board meeting, and it's a companion with item 6, which is a CP 22002. We have Mr. Taub, who is representing the applicant. This is an evidentiary hearing, so I'll require those who are intending to provide, potentially even to provide testimony, to take an oath. So if all of those persons who are intending to provide a testimony, if you could come on screen, please. Even if you're part of the applicant's team, as long as you're not the attorney. And if there's anyone in opposition who wishes to speak as well. Okay, do you solemnly, please raise your right hand. Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth? I saw and I do. Thank you, Mr. Hill. We don't have anyone else. So consider yourself sworn in. We have Ms. Lockhart, who will be giving the staff presentation. Ms. Lockhart, I will turn it over to you.
Wait a minute.
Thank you. Good morning, Chair Shapiro and members of the Planning Board. For the record, I am Dominique Lockhart with the zoning section. The application before you are items 5 and 6 on the agenda, detailed site plan DSP 8611615 and conservation plan CP 22002 for Waterside Subdivision Hill residents. On April 14th, the applicant's attorney submitted a waiver requesting a continuance to the May 18th Planning Board hearing date. Staff has since then received additional information from the applicant's team. The continuance was to allow staff time to review the provided information and publish a revised staff report. The applicant has also provided a 45-day waiver of the Planning Board action limit. Staff recommends approval of this request for continuance. Thank you.
Thank you, Ms. Lockhart. Any questions for staff before we turn to the applicant? Seeing none, Mr. Talbot, am I turning to you or Mr. Hill? What do we have?
Mr. Hill is present.
I'm not sure where, I thought I saw Larry, but in any case, I can speak.
Okay, let's just take a second, Mr. Hill. See if he's online. I don't see him. Kenny or Ryan, do you see him?
No, he's not on the list.
Okay. Okay, Mr. Hill, then the floor is yours. And again, this is a request for a continuance.
Yes, so we've been working together with staff to just clear up some remaining questions. I think we're in a good place now. So yes, we would like to proceed with the continuance until the 18th, please.
Okay, thank you, Mr. Hill. Commissioners, any questions for Mr. Hill, for the applicant? No questions. I just want to check the sign-up sheet because we have a few folks who are carried over from other hearings. The only person who I see who isn't part of the applicant's team is Mr. Borofsky. Are you on the line? Are you planning to speak on this? Okay. There's no one else. Is there anyone else who is looking to speak on this? If not, I will close this evidentiary hearing. Mr. Warner, I'm not actually having an evidentiary hearing if this is just a request for continuance, am I?
That's correct. Yeah, no need to open the hearing on this particular case. If
Well,
they're just going to ask for a continuance.
We'll continue it.
Close it.
The request for continuance in any case. So commissioners, you have a request for continuance before you. What's your pleasure?
Move to approve the request for continuance, Mr. Chairman, for DSP 86116-15 and CP-2202 until the May 18th hearing date.
Second.
Okay, we've got a motion by Commissioner Washington, second by Vice Chair Bailey. Mr. Warner, we've taken up both these requests for continuance in one motion. Is that appropriate?
Yep.
Thank you. So we have a motion for continuances for these two items that are companions. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
Aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Giraldo.
I vote aye for the continuance.
I vote aye as well. The ayes have it 5-0 for the two items. Thank you, Mr. Hill. We will see you down the road.
Thank you, sir.
And thank you, Ms. Lockhart, of course. So we'll move on to item 7. By the way, I've made one change to the order in which we're going to take up cases. We're going to take up item 10 before we take up item 8 and 9. Otherwise, everything will stay the same. Okay? So next on to item 7. This is DSP 21034, Advanced Auto. Let me just make sure. Bear with me, folks. Okay, so this is an evidentiary hearing. So again, we're requiring those attending to provide testimony to take an oath. So at this time, I would ask all persons intending to provide testimony to raise their right hand. Who do we have beyond the attorneys? There we go. Other folks. Do you solemnly swear or affirm that your testimony will be the whole truth and nothing but the truth?
I do.
Okay, consider yourself sworn in. We have Mr. Haller representing the applicant. We have Ms. Gupta, who will be giving the staff presentation. I will turn it over to Ms. Gupta. Take it away.
Good morning, Mr. Chair. Doing a sound check. Can
Yep, we can hear you
me?
fine. Thanks for checking.
Great. Thank you. Good morning again, Mr. Chair and members of the Planning Board. For the record, I'm Ridula Gupta with the Urban Design section. Item number 7 on the agenda is a detailed site plan, DSP-21034, titled Advanced Auto, which proposes construction of a 6,888 square foot building for a vehicle, parts, or tire store. As a matter of housekeeping, the additional backup includes 3 exhibits received from the applicant prior to the May 2 noon deadline. Next slide. The subject property is in Planning Area 72 and Council District 5. Next slide. More specifically, the subject site, which is little over an acre and outlined here in red, is located on the northwest corner of the intersection of Maryland 214 or Central Avenue and Norair Avenue. Next slide. The image to the left shows that the subject site, outlined in red, is split zoned. Western portion of the site is in the local transit oriented edge zone, and the eastern portion is in the commercial, general, and office zone. This detailed site plan, however, is reviewed in accordance with the prior zoning ordinance, under which the site is within the mixed-use infill or MUI zone, as shown in the image to the right. Next slide. The subject site, outlined in red, is located within the Military Installation Overlay, or MIO zone, under both the prior and current zoning ordinance. Under the prior zoning ordinance, as shown in the image to the right, the property is located in the Development District Overlay, or DDO zone, of the 2010 approved subregion 4 master plan and sectional map amendment. Next slide, please. The aerial photograph shows that the site, outlined again in red, is vacant. Next slide. The slide shows that the site, which is delineated in purple, is generally flat. Next slide. The slide shows Central Avenue, which is classified as an arterial road, highlighted in red, and located on the south side of the site. Next slide. This is the bird's eye view of the site, which is outlined in red. The site is bound to the west by an office building and a gas station, and to the north and northeast by single-family detached dwellings. East of the property is Norair Avenue with vacant land beyond. South of the property is Central Avenue with various uses beyond, including an auto repair shop and a church. Next slide. At the time of the preliminary plan of subdivision approval, the Planning Board had discussed issues of concern considering the site's proximity to the metro station and had expressed the desire that the site be designed in an urban format with attention to on-site pedestrian and bicycle safety considerations. This detailed site plan is in response to that. The applicant proposes to construct a one-story building for a vehicle, parts, or tire store without any installation facilities. The building is oriented towards and has pedestrian and vehicular access from Central Avenue. No vehicular or pedestrian access is provided from Norair Avenue, given the narrow frontage of the property along this street. Parking is provided to the site and rear of the retail building, and bicycle parking is provided near the entrance door. The loading and trash facilities are located in the rear and the side of the site and screened from direct public view. The proposed streetscape includes sidewalks along the frontage of Central Avenue and Norair Avenue, and a bicycle path along the frontage of Central Avenue. A lead walk connects the building entrance to Central Avenue. Stop signs and pavement markings are provided at both driveways to ensure pedestrian safety at points of conflict with vehicular traffic. The site design integrates building and pole-mounted lighting throughout the site for illuminating site access, drive aisles, building entryways, and walking paths. Pedestrian-scaled light fixtures are located at even intervals around the site and are oriented into the property to avoid any light intrusion into abutting residential properties. The retail building is pushed as close to the build-to line as practicable, and the site frontage is extended using a 3-foot-high masonry wall to provide a continuous urban street facade. The 2010 approved Subregion 4 Master Plan includes standards for this development district, which contain regulations that impact the design and character of the Central Avenue corridor. This application generally meets the standards of the development district. However, the applicant is requesting modifications to several development district standards. These alternate standards may be approved if they can be found to benefit the development and the development district and will not substantially impair implementation of the master plan. The applicant's request, staff analysis, and recommendations for these requested modifications are presented in finding 7 of the staff report on pages 9 through 15. Next slide. This slide shows the landscaping proposed for the project in accordance with the applicable sections of the landscape manual. The plan provides landscaping along the street frontages for the parking areas and planting for screening and buffering. Alternative compliance AC-23003 was filed with this detailed site plan from the requirements of section 4.7, buffering incompatible uses of the landscape manual for the northern and northeastern property boundaries abutting single-family residential uses. Staff recommends approval of the alternative compliance as further detailed on pages 21 through 23 of the staff report. Next slide.
Hello, Robert. Hey, were you able to find the link? The email, the links in the email.
Thank you. The ski map shows the locations of the viewpoints A, B, and C for perspective views of the proposed development, which follow in the next 3 slides. Next slide. This is view A looking northwest from the intersection of Central Avenue and Norair Avenue. The view shows the proposed sidewalks and bike lane along the property's frontage. The proposed site-tight fence and landscape screening next to the adjoining dwellings at the rear can also be seen. Next slide. This is view B looking north towards the site from Central Avenue, showing the main vehicular entrance into the site, the pedestrian connection to the front from Central Avenue, and the street frontage. Next slide. View C is a bird's eye view looking northwest into the site. Next slide, please. This slide and the next show elevations of the proposed retail store. The architectural design is contemporary and presents a modern retail storefront. The facades facing Central Avenue and Norair Avenue are articulated with color variations, projections, awnings, material changes, storefront glass, and articulated roof line. Next slide. These are the elevations of the facades facing the rear parking and loading area. All facades use a variety of colors and finishes to provide architectural interest. Next slide. This slide shows details for the proposed site signage, which includes building mounted signs facing Central Avenue and Norair Avenue. Next slide. This slide shows the truck turning exhibit. Next slide. As mentioned at the beginning of the presentation, the applicant has submitted 3 exhibits, which are included in the additional backup. The applicant has proffered 3 additional conditions of approval in their Exhibit 1, which they will detail in their presentation. Applicant Exhibit 2 reflects the proposed modifications to the detailed site plan, which will improve pedestrian and bicyclist safety along Central Avenue. Staff has reviewed the proffered conditions and has no objection to them being added. Applicant Exhibit 3 provides perspective views of the proposed development. In conclusion, staff recommends that the planning board adopt the findings and approve detailed site plan DSP-21034, approve the alternative development district standards listed on page 29, and approve alternative compliance AC-23003, subject to the conditions found in the staff report, with additional conditions as proffered by the applicant's Exhibit 1. This concludes staff's presentation. Thank you.
Thank you, Ms. Gupta. Let me just say how pleased I am that the applicant was responsive to the concerns that we were discussing under the preliminary plan of subdivision. So certainly happy with that. Commissioners, any questions for Ms. Gupta? Seeing none, I'll turn to Mr. Haller.
All right. Good morning, Mr. Chairman, members of the board. Thomas Haller, attorney with offices in Largo, on behalf of the owner and applicant in this case. First of all, I wanted to thank your staff, and I want to thank the planning board for the comments that we received during the preliminary plan. Those were helpful to us in determining the best layout for the site. I also want to thank the adjoining neighbors, as well as Mr. Borofsky, who we've met with and discussed some of their concerns, and those were the genesis of the revised conditions that we are proposing. But just to give a little bit of a context to the site, as you can see, it's not a rectangular shaped site. It's got some challenges with regard to its size. And so one of the things that the board asked us to do was to work very diligently to create a much more urban streetscape. Fortunately, because this property was subject to a development district overlay zone that had provisions which allowed for and encouraged a urban streetscape, we were able to push the building further to the road than what we had originally proposed conceptually. One of the design standards in the DDOZ is to is street frontage or street occupancy, and it would normally require 80% of the site be occupied by a building, but for a property of this size and shape, that literally would be impossible for any use. But the DDOZ standards that kind of anticipated that, and instead indicated that where you could not do that, that you should place a low wall to create a much more urban streetscape and to hide parking. And as you saw from the perspectives that we provided, we have provided that treatment along the front. We also have some challenges with regard to the existing streetscape. There are existing poles, electrical poles, that we can't move. And so we have enhanced the sidewalk along the road frontage to the extent that we can. We are widening it. And while we can't put landscaping between the sidewalk and the road, we are adding ample landscaping in front of the low wall that we've provided around the site. So we're doing a number of things to try to enhance the urban streetscape along this area. I mean, this building, when constructed, will be the closest building to the street, will be the most urban in form along this stretch of Central Avenue. If I could ask staff to go to slide 11 in the PowerPoint presentation, which is the landscape plan. I just wanted to note a couple of things there. When we met with the abutting property owners, and we first met with them back during the preliminary plan, and one of the things they asked us to do was to provide ample buffering and screening along our rear property line. And so you can see that we have provided a landscaping along the north property line and the northeast property line. And one of the things that they asked us to do was to provide evergreen trees so that there would be a complete screen. So what we have proposed is not only a 6-foot tall site type fence along our real property line, we have about 200 evergreen trees that will be constructed along that property line to create a literally complete screen around the property. And by pushing the building further toward the road or closer to the road, we've almost doubled the setback that's normally required under the landscape manual. So we think that that has been responsive to their concerns. And when we met with them with the final site plan, they were very pleased with the extent of the landscaping, the type of the landscaping, and the buffering that we've provided. The other thing that I wanted to discuss is our proposed modifications to the site plan. And if I could ask if we could go to the applicant's exhibit 1, which is the applicant's proposed additional conditions. And there are 3 additional conditions we proposed to add to condition 1. While I could read them, I think it might be helpful to go to the next page. We put together a simple exhibit to show what these conditions are intended to require. There you go. There's the site plan there. So the first condition says depict 2 speed bumps, one after the westernmost parking space near the north side of the building and one prior to the westernmost driveway exit. The second condition says add 2 directional signs at the western end of the northern parking area, directing customer traffic toward the eastern driveway exit onto Central Avenue. When we met with the representatives of the property owners that abut us and Mr. Borofsky, one of the concerns that Mr. Borofsky raised was that as you are walking or bicycling along the front of this property, if you're coming from Norrell Avenue, you can see cars coming in and out of the easternmost entrance very well. His concern was that because we pulled the building so close to the street, he was concerned that there would be less visibility for if cars exited the site from the western exit. And so as a result of that, what he requested was 2 things. Number one is to make sure that cars are not moving quickly as they exit the site if they go out that way. And so while we've got a stop bar at the exit, he suggested that we add a speed bump not only at the exit but also as you enter that driveway, simply to make it more difficult for people to want to even go that way. So that if you are a customer in the site, you would have to maneuver across 2 speed bumps before you get to the exit, which would ensure that you're not moving quickly as you exit the site. The other thing that he suggested that we've agreed to is to add some signage at the end of the parking field that essentially directs traffic back toward the eastern entrance. And what we indicated to him was we anticipated most of the people would come in and out of the eastern exit anyway, but he asked that we put signage that actually directs people that way. And so you can see on this exhibit where the speed bumps are intended to be located and where the signage is intended to be located to direct customers back to the eastern exit. And we were more than happy to accommodate that request. The third request that Mr. Borofsky had, which is reflected in the third condition we proposed, is to increase the height of the diagonal portion of the landscape wall at the corner of Central Avenue and Norrell Avenue from 3 feet in height to 4.5 feet in height. And if you look in the far right side of this image, you'll see where I'd say increase the height of the wall to 4.5 feet. So that diagonal area of wall, I don't know if the cursor can go over to that location, but there is a diagonal section of wall that runs from Central Avenue toward Norrell Avenue. And if I could ask if we could go to the final, I guess it would be the perspective, the second perspective that's included of the corner. It'd be image 5. There you go. So if you look at that perspective and you see the low wall that angles along going from Central Avenue to Norrare Avenue, what Mr. Borowski said was that when the McDonald's restaurant was reconstructed down the street, there was a drive-through that was constructed on the south side of the building. And as cars are facing traffic traveling westbound on Central Avenue, their headlights shine into the cars that are traveling westbound. And he found that to be distracting and unsafe. And so what his concern was is that if somebody pulls into our parking lot and turns to the right to park, that those headlights will be facing east as the cars are traveling west. So what he asked is that we increase the height of the knee wall along this section of the wall to 4.5 feet to make sure that that blocks the view of the headlights for any vehicles that are trying to park. And my client readily agreed to do that. So along that approximate 50-foot stretch of the knee wall, the brick wall will be a little bit higher to make sure that it prevents headlights from shining into the eyes of people that are traveling eastbound on the road. And so we agreed to make these changes and are happy to offer them to the board to adopt as modifications to the staff's recommended changes. We have no other concerns or objections about any of the other staff recommendations. I think we have 3 members of our team here today. We have both of our consultants, Mr. Mike Lenhart and Mira Gansert with Bowler Engineering. And then the owner of the property, Mr. Halal, is also on and can answer any questions that you have. But again, I want to thank the board for your direction in terms of trying to improve the streetscape along this property. And I want to thank the neighbors for their suggestions in terms of making this a better layout. And I'm happy to answer any questions that you have.
Thank you, Mr. Howard. Let me just say again, thank you for your responsiveness to us, to the folks in the community, your collaborative approach with staff as well. It's great to hear. Commissioners, questions for Mr. Haller or any other members of the advocates team?
No questions, Mr. Pittman.
Okay, I've got Commissioner Geraldo and then Commissioner Washington.
Quick question. What material is going to be used on the wall, Mr. Haller?
It's going to be to match the brick on the building.
Okay, good enough. Thank you.
Thank you. Commissioner Washington?
No questions. I really wanted to associate myself with your comments and thank Mr. Haller for not only hearing, but really doing a nice job incorporating all the comments from everybody to include the neighbors, us. I think this is a really nice project before us. So thank you.
Thank you very much.
One quick question, which is what is the detail going to look like where the 3.5-foot wall connects with the 4.5-foot wall connects to the 3-foot wall?
We had a conversation whether it'd be necessary to actually step it up or because it's at a break in the wall anyway, whether it could just rise up. I think that's a detail we can work out with staff. If we come up with a revised image and show what it would look like, if staff or we'll come up with something we think provides an appropriate transition. If staff wants to adjust it, we can do that as well. I mean, it could easily step up. It's going to have a cap on it. And so I think that it would not look inappropriate at all for it to simply get higher for 1.5 feet where that break is. But like I said, it's going to rise where there's a natural turn in the wall anyway. And since it's going to have a cap on it, I think it will look appropriate, whether we try to gradually increase the height or whether we just do it as one quick increase.
Great. Yeah, it sounds like you're paying attention to it, and I'll trust staff and you all to work out the detail. Thank you. Commissioners, any other questions for the applicant? No other questions. We have no one else signed up to speak on this. I believe I'm correct. Anyone I'm missing? If not, then I will close this hearing. And commissioners, we can deliberate, or if there's no deliberation, what is your pleasure?
Mr. Chairman, I move that we adopt the findings of staff and approve Alternative Development District Standards A 1 through 5 as outlined in staff's report, in addition to approving DSP-21034 and AC-23003, along with the associated conditions as outlined in staff's report, and also incorporate conditions 1U through W as detailed in applicant exhibit number 1.
Got a motion by Commissioner Washington, second by Commissioner Giraldo. Any discussion on the motion? No discussion. I'll call the roll. Commissioner Washington.
I vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Vote aye.
Vice Chair Bailey.
Vote aye.
I vote aye as well. The ayes have it 5-0. Thank you, Mr. Haller and your team. And thank you, Ms. Gupta. We'll now move on to item number 10. This is an extension request for a preliminary plan 4-20021 Brandywine Woods Conservation Subdivision. Again, this is an extension request. We'll turn to staff and then we'll hear from the applicant represented by Mr. Tedesco. Mr. Diaz-Campbell, floor is yours.
Yes, good morning, Mr. Chairman, members of the board. Can you hear me, please?
Yes, we can hear you fine. Thanks for checking.
All right, great. So yes, for the record, I am Eddie Diaz-Campbell with the subdivision section. Item number 10 on the agenda is an extension request for preliminary plan of subdivision 4-20021 Brandywine Woods. This preliminary plan of subdivision approved 165 lots, 17 parcels, and 1 out parcel for development of 165 single-family detached units in a public benefit conservation subdivision. The preliminary plan was approved by the planning board on April 15, 2021, and is valid through May 6, 2023. By letter dated April 14, 2023, the applicant requested a 2-year extension of the plan's approval. This is the applicant's first extension request. If this request is approved, the preliminary plan of subdivision will be valid through May 6, 2025. Staff has provided a memorandum which evaluates the extension request for its conformance to the required criteria for approval of extension, which are contained within the prior subdivision regulations. And staff recommends approval of the extension request. This concludes staff's presentation. Thank you.
Thank you, Mr. Diaz-Campbell. Questions for staff, commissioners? No questions. I'll turn to Mr. Tedesco.
Good morning, Mr. Chairman. Can you hear me okay?
We can hear you fine. Thanks.
Fantastic. Good morning, Mr. Chairman, members of the planning board. For the record, Matthew Tedesco at the law firm of McNamee Hosey here on behalf of the owner and applicant, Tower Terra LLC. Unless there's any questions or issues or concerns by the planning board, we're prepared to submit on our written request and justification, which is a letter in your backup dated April 14th. We also are in agreement with staff's recommendation for the extension, and we would submit, happy to answer any questions. We want to thank staff for their review, not only of the parent case, but this extension request. And the reasons for the extension are provided in the memo that staff prepared, and fully meet the requirements of 24-119 D5A. So with that, Mr. Chairman, unless there's any particular questions or concerns, I'm happy to submit on our request and respectfully request that the extension be granted.
Thank you, Mr. Tedesco. Commissioners, any questions for the applicant? No questions. We have our staff is recommending approval of a 2-year extension. What is your pleasure?
Chairman, I move that we approve the 2-year extension for preliminary plan 0021.
Second.
Got a motion to approve a 2-year extension by Commissioner Washington, second by Vice Chair Bailey. Any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington.
I vote aye.
Vice Chair Bailey.
Vote aye.
Commissioner Dorner.
Vote aye.
Commissioner Giraldo.
I vote aye.
I vote aye as well. The ayes have it 5-0. Thank you, Mr. Tedesco. Thank you, Mr. Diaz-Campbell.
Thank you. Have a good day.
You too. So, commissioners, before we move on to items 8 and 9, I need to beg your indulgence, and I'd like to take a 10-minute break. So it's 10:39. Let's break until 10:50. Okay?
Okay. Thank you.
10:50. It's 10:50. We're back from break. Thank you all for your indulgence. We have 2 final items before us that are connected. Item 8 is a waiver of our rules of procedure. in advance of the request for reconsideration this is related to item 4-05027 Willow Ridge Estates. I have Commissioners, I have no objection to us waiving our rules of procedure and getting to the request for reconsideration. And then I want to talk through with you all exactly what I think makes the most sense for proceeding on this. So again, what is before us first is the waiver of the rules of procedure. We can, again, I'm going to turn to the person who's making the request, but keep in mind, I don't think we're going to have any issues with waiving the rules of procedure, and then we'll get into discussion about the actual request for the reconsideration hearing. So, Ms. Scudder, anything related to this, the waiver, before we get into the substance of things?
Good morning, Chairman Shapiro and members of the Planning Board. For the record, Tracy Scudder, counsel for Ms. Gloria Shepard, who's a party of record in this case. On her behalf, I submitted this request to reconsider a condition that the Planning Board created in this case to ensure that a small sliver of land would be conveyed to Ms. Shepard to provide access to her landlocked property. I am prepared to argue this matter this morning, and Chair Shapiro, I don't know how far you would like me to go at this time, but I do believe there is.
At this time, all we're doing is waiving the rules of procedure. Then we'll get into a discussion for the request for reconsideration.
Okay.
So anything else that you have for us? If not, commissioners, if there's any questions for Ms. Scudder just related to this waiver, or Mr. Haller, anything that you want to jump in on? Again, this is just related to the waiver. Then we'll get into the substance on the request for reconsideration, and I'm sure we're going to hear from both sides on that.
Mr.
Okay,
Chairman,
I'm sorry.
No,
I would like to just mention.
Mr. Haller, hold on one sec. Mr. Haller, one second. I think Ms. Scudder wants to finish her thought. Then we'll turn to you. That's all right.
It probably would be prudent for me to at least, put something on the record with regard to, waiving the rules, because we do believe there's good cause here to suspend the rules so that Ms. Shepard can be heard. One thing I wanted to mention is that, Ms. Shepard missed a recent opportunity to come before the Planning Board when the last reconsideration was filed the reconsideration request was filed in 2020 by the current developer. And though she is an adjoining property owner and she has participated in this case over the years, she did not receive notice of that reconsideration request. The parties of record list, it lists her address as 9207 Foxcroft Avenue, Clinton, Maryland, an address that is unknown to her and which is not an address where she has ever resided. And obviously we recognize that, this is most likely an inadvertent mistake. Nonetheless, it cost Ms. Shepard a missed opportunity to participate in that reconsideration hearing, which, by the way, was all about transportation improvements in the area, the streets and the roads. And Ms. Shepard's condition 17 that we would like to have a reconsideration on today is also related to future public roads that would give her access to her land. Ms. Shepard would have wanted to participate in that hearing. And because, she was the subject of an inadvertent mistake, that resulted in the denial of her right to have received notice about a case that directly affects her property. And so we are asking that you also please take this into consideration as you decide on the waiver. Thank you.
Thank you, Mr. Haller. Again, all that is before us at this moment is whether or not we're going to waive our rules of procedure and discuss the request for a reconsideration hearing, not have a reconsideration hearing, but just discuss it. So this is purely procedural, Mr. Haller. Anything else on the waiver?
Yes, Mr. Chairman, Thomas Haller on behalf of the property owner. I just wanted to note that we have no objection to the board granting the waiver and allowing Ms. Shepard to provide her position to the planning board.
Okay, thank you, Mr. Haller. So commissioners, we've heard from Ms. Scudder, we've heard from Mr. Haller. Again, I'm fine with granting the having a waiver of our rules of procedure. Any further comments on that? If not, I'd look for a motion.
Mr. Chairman, I move that we waive the rules of procedure for preliminary plan 4-05027.
Second.
We've got a motion by Commissioner Washington, a second by Commissioner Giraldo. Under discussion, Mr. Warner, any concerns around our process so far? Yep. Take your time.
No, not whatsoever. The board normally suspends its rules as opposed to waiving them, which is just a legal difference of opinion on that word, but the intent is obviously achieved by your motion. And then just to remind the chair and the board that a request for reconsideration is not in itself a hearing. That is just a request by an individual person of record, in this case, who can be allowed to present their case, and any property owner who's impacted by it can be allowed to represent their case. But it's not a public hearing where everyone is given the opportunity, required to be given the opportunity to speak.
Thank you, Mr. Warner. Okay, we've got a motion. Again, the motion was by Commissioner Washington, the second by Commissioner Giraldo, if memory serves. Yes? Yes.
Yeah.
No further discussion. I'll call the roll. Commissioner Washington.
I vote aye.
Commissioner Giraldo.
I vote aye.
Commissioner Dorner.
Vote aye.
Vice Chair Bailey.
Vote aye.
I vote aye as well. Let's have it 5-0. We have waived or suspended our rules of procedure. And now what was before us is a request for a reconsideration hearing for a preliminary plan. I'm going to turn to staff first. So we'll have Mr. Heath, who will take this up. Then we will hear from Ms. Scudder, representing the applicant. To Mr. Warner's point, this is not a public hearing. So we are not going to go through a list of all people who have signed up to speak, as you might expect from a public hearing. If there are any affected property owners, in addition to Ms. Shepard, an affected property owner will be afforded the opportunity to speak. But folks who just want to weigh in on the pros and cons of this, who are not affected property owners, will not have the opportunity to speak, because this is not a public hearing in the sense that most of us are used to, okay? So that's how we'll proceed. We'll start with Mr. Heath, and the floor is yours.
Chairman Shapiro, I'm sorry to interrupt you, but would this be the right time to bring up a preliminary matter, or should I wait until it's turned over to me?
Why don't we wait until it turns over to you, unless there's some reason you think that we will not be proceeding today.
No, sir.
Okay. Mr. Heath.
Thank you. Good morning, Mr. Chair, members of the board. For the record, Antoine Heath with the subdivision section. Item 8 is a reconsideration request for a preliminary plan of subdivision 4-05027 Willow Ridge Estates. The party of record, Ms. Gloria Shepard, has submitted this reconsideration request specific to condition 17 of the resolution. The resolution of the case was adopted by the planning board on March 30th, 2006 and mailed on April 4th, 2006. And the request is being made by, again, Ms. Gloria Shepard, who's the party of record and adjacent property owner to the subject preliminary plan. There are 3 items of additional backup. First is a letter of opposition from the applicant. The other 2 items are photographic exhibits provided by the party of record. To give some background, I'll briefly go through some of the overview slides. Slide 2, please. The subject property is located in Council District 9 and Planning Area 81A. Slide 3, please. More specifically, the property is located half a mile west of Dangerfield Road and Woodyard Road intersection. Slide 4, please. The subject property is located in the rural residential zone in both the prior and current zoning ordinance. Let's skip to slide 6, please. This is an aerial view of the property and its current condition. Let's skip to slide 11, please. This slide shows the property boundary of the approved preliminary plan of subdivision outlined in red. To the south of the site is the Shepherd property known as parcel 128, which is marked with a purple star. The parcel is to be conveyed to the owner of parcel 128, and that's highlighted in blue. Condition 17 requires the applicant to provide a note on the preliminary plan of subdivision, which indicates that the parcel C of the subdivision is proposed to be conveyed to the owner of parcel 128, which is Ms. Shepherd. The property or the party of record has requested to reconsider condition 17 of the resolution. This condition was met at the time of signature approval of the preliminary plan of subdivision. However, it is alleged that there was an error and that the condition did not include a time at which the property must be conveyed. The modification being requested by the party of record would establish a specific time in which the conveyance is to take place. At the time of the preliminary plan of subdivision approval, the applicant proffered to convey parcel C to Ms. Shepherd as the owner of parcel 128, considering that parcel 128 was landlocked and did not have access to a public right-of-way. Conveyance of parcel C would allow the Shepherd property to connect to the future public right-of-way Canberra Place. Condition 17 was authored as a result. Reconsideration may only be granted if, in furtherance of substantial public interest, the planning board finds that an error in reaching the original decision was caused by fraud, surprise, mistake, inadvertence, or other good cause. In this case, the party of record identifies the omission of a definitive time for conveyance as an error. However, staff finds that the omission of a definitive time is not an error and that a condition for timing would be inappropriate for the following reasons. As stated in the resolution, the conveyance of parcel C was proffered by the prior property owner as a courtesy and not necessarily for the approval of the preliminary plan of subdivision, as conveyance of this land is not needed to achieve public facilities adequacy for the subject subdivision. Also, it is likely that parcel C will need to be retained by the applicant for an unspecified period of time, as it is anticipated that grading for the installation of infrastructure for the development will include necessary grading of parcel C. And this is shown on the approved preliminary plan. Additionally, timing may be affected by the terms of the conveyance of land, which should be established via a private agreement between the two parties. Private agreements for land conveyance may include provisions for rights, restrictions, compensation, and other factors not readily under the review of the planning board. The terms of conveyance would need to be agreeable to both parties to complete the conveyance, and these factors should not prevent the development from proceeding. It is noted that the planning board has approved other preliminary plans of subdivision with similar proffers for conveyance to abutting property owners, which also do not include specific timing in their conditions. In this case, the resolution of approval makes clear the conveyance of the land was a proffer from the applicant, and that this was not expected that the land to be conveyed would negatively affect the development of the subdivision. The applicant has recorded the lots and parcels approved with the preliminary plan of subdivision and provided the required note in accordance with condition 17. However, development has not yet taken place. Conveyance of parcel C should occur at an appropriate stage of development for the subject subdivision when determined practical to do so by the owner or developer and pursuant to a private agreement of the involved parties. Slide 12, please. Given these factors, staff finds that it would not be appropriate to condition the timing of the conveyance and that no error occurred. This concludes staff's presentation.
Thank you, Mr. Heath. Commissioners, we may hear from staff again as we proceed, but are there any questions at this point regarding their recommendation regarding the request for reconsideration hearing? No questions. Okay, so we'll turn to Ms. Scudder. I assume we'll be hearing from you. I assume we'll be hearing from Ms. Shepherd. I have a procedural matter, though. There are a number of folks who were signed up in support of Ms. Shepherd's position, and I'm trying to get a handle on who here actually is beyond folks who are just quite legitimately being supportive of Ms. Shepherd and her position. Are there any folks who are actually directly affected parties? We're talking about property owners who, based on this decision, their property would be affected. So Ms. Scudder or Ms. Shepherd, could you help me with that? I mean, I've got Mr. Maddox, I've got Mr. Henderson, I've got Rabia Muhammad, Larry Johnson, Jermaine Wilson, Octavia Brooks, Morrison, and Marie. So of those folks, are any of them affected neighboring property owners?
I would say no, but I didn't recognize a number of those names, so I would ask my client, Ms. Shepherd, to respond.
Thank you, Ms. Scudder. And Ms. Shepherd, again, this is procedurally, I just want to get this clear before we proceed. So,
Jason Shepherd is my son, so he would be affected by the results of this.
that seems fair, Ms. Shepherd. Anyone else?
I have a Robert Reed, who also helped me, an engineer, and Eugene. That these are other people that's in my favor, but the only one that as actually would affect would be the heir, which would be my son, Jason Shepherd.
Okay, Ms. Shepherd, thank you for being very direct about that. I very much appreciate that. So we will afford both you and your son, Mr. Jason Shepherd, the opportunity to speak as well on the request for the reconsideration hearing. And again, this is for you, Ms. Scudder, Ms. Shepherd, and Mr. Shepherd. What is before us is whether or not we would grant the request for a reconsideration hearing. We grant that if it is determined that there was an error made. Staff is crystal clear that there is not an error made. I would ask you to keep the substance of your talking with us to if there was an error made, what was the error, how it affected you. Let's just keep it to that, because this is not a reconsideration hearing. This is just a request for the hearing, which is determined on whether or not an error was made through the original process, okay? So with that, I'm going to turn to Ms. Scudder, and then after that, Ms. Scudder, I assume we'll want to hear from Ms. Shepherd and Jason Shepherd as well. And then after that, we'll hear from the applicant represented by Mr. Howell. And that's all the folks who will be speaking, unless we have questions for any folks who are on the list. Ms. Scudder, the floor is yours.
Thank you, Chairman Shapiro. I will adhere to what you just said. I think that there is some explaining that has to be done to establish context, but I will keep in mind your words. I'm going to start by thanking Mr. Heath, who is always a pleasure to work with. I would also like to thank Mr. Howler for taking a friendly position and not opposing the suspension of rules. But on behalf of my client, Ms. Gloria Shepherd, I do need to address Mr. Howler's participation in this case. I have a lot of respect for Mr. Howler, and I think this is probably the first time I've ever been opposite of him in a case. But I have to object to Mr. Howler testifying against his former client today. And I would also request that any material that he has submitted be stricken from the record. Mr. Howler represented Ms. Shepherd at the Planning Board in 2006 on this same preliminary plan of subdivision application, and with respect to the very same issue that we are here on today. And I believe he represented her over the years with respect to contract negotiations with the prior developer.
I'm going to stop you. Let me interrupt real quick. What I'm hearing is you believe there may be some kind of ethics violation. I do not see how that is in any way, shape, or form relevant to the proceedings today. And Mr. Warner, maybe you could help me with this.
Well, Mr. Howler is on the other side.
Yeah, but we're the planning board, and we have a request for reconsideration hearing before us. I'm missing the relevance of that. Mr. Warner, can you chime in on this?
Well, I think it would be appropriate, at least for, I've got part of Ms. I've got part of Ms. Scudder's argument here. I think she should finish her the basis for her, which sounds to me like a request for some type of preliminary motion. And I would let her at least complete that so I get the full facts. And then I think it would be appropriate for Mr. Haller to respond. And then we can make a decision after that.
Okay, thank you for that advice. And Ms. Scudder, apologies for jumping into you quickly, and continue, please.
No problem. I'll be brief. As I was saying, I believe he represented her over the years with respect to contract negotiations with the prior developer and the current developer as to the conveyance of Parcel C. As recently as 2015, he was still Ms. Shepard's attorney, I believe. And, presently, he is the attorney for the developer on the very same issue that he previously represented Ms. Shepard on. And he's taking a position that's adverse to his former client. And she has not waived this conflict. And we believe this is inappropriate. And on behalf of Ms. Shepard, I am respectfully requesting that he recuse himself and that his materials be stricken from the record in this request. That's all I have.
Thank you, Ms. Scudder. So following the advice of counsel, we'll hear from Mr. Haller.
Thank you, Mr. Chairman. Thomas Haller on behalf of the property owner. Just to provide some context to the planning board. I was retained by Ms. Shepard in 2015 before the current owner of the property acquired the property. She asked me to inquire as to whether the owner would convey the property to her at that time. We could not, we had a very difficult time finding the property owner. But ultimately we're told that the property owner was not in a position to convey it because they needed the property for development of the property. I then was no longer working for Ms. Shepard, and then this property was sold to the current property owner along with other projects in the county. And so I kind of inherited this project when that new property owner obtained it. And I've been trying my best to get this property in a position where it could be developed so that the property can be conveyed to Ms. Shepard. And so I do not believe that I have a conflict. Ms. Shepard obviously is represented by other counsel. And we have never, and as in my role with regard to the current property owner, I've never taken the position that the property will not be conveyed to Ms. Shepard. It's merely a question of the fact that the property is needed in order to develop the property in order to be in a position to be conveyed. That at least that would be my position.
So you do not feel that you need to recuse yourself on this matter?
No, I do not.
Okay. Mr. Warner, do you want to weigh in?
I will. Okay, so an attorney is subject to ethics, conflict of interest rules, professional responsibility pursuant to the rules adopted by the Maryland courts, and also subject to conflict of interest laws and things like that developed by the courts through the common law. And if there were a potential conflict, that would be a matter that would fall within the jurisdiction of the courts to resolve. It's not something for the planning board to make a decision on. I don't think it's appropriate for this body to make a decision on whether an attorney has a conflict or not. I think that falls outside of our jurisdiction. So in this particular case, I would, if we characterize Ms. Scudder's request as a motion to remove the documents that Mr. Haller has presented or to somehow not receive his testimony, I don't think that would be appropriate.
Thank you, Mr. Warner. I agree with that. Commissioners, any questions or concerns around this?
I just want to ask, is it appealable then? So if we're not supposed to be making the decision on whether or not there's a conflict of interest that we should resolve, would Ms. Scudder have appeal ability to raise that issue at the court if we say no today and it comes in? Can she then get to the court and appeal the decision if it's not in her favor?
Actually, this is Commissioner Giraldo. I don't know if it would be the court where she would have to file something with the Office of the Disciplinary Council if she believes that there's a violation of the rules of professional responsibility.
I agree with that. Yeah, there is always an avenue for any individual to bring a complaint that an attorney is acting outside of the rules of professional responsibility. I don't know how that would ultimately affect a decision of this board on whether to reconsider its own decision, which really falls within solely the jurisdiction of the board. And I don't know that a court could step in and change our decision, but I don't think that's an issue that should be considered at this time. It's probably something that we'd have to research. But I think that the resolution of the issues that Ms. Scudder is bringing up are really outside of our jurisdiction, handled through a different process.
Okay, thank you. Other questions or thoughts, reactions?
Well, only this, Mr. Chair. So if we're sitting as an administrative tribunal, I know that if this was before a court and the issue was raised, that a judge in a court hearing would definitely might very well do what Ms. Scudder is asking. But we're in the context of an administrative tribunal, so I don't know if that would apply equally.
Right. I don't believe it does because of, it should generally be like a separation of powers argument, right? While we sit as a tribunal and we carry out certain procedural processes that are similar to a court, we're still a body outside of the judicial arm of the state. And so acting in our separate capacity, in our legislative capacity, I don't think this falls within our jurisdiction. Yes, we use certain court procedures, but we're not a court, and I don't think this falls within our authority.
Okay.
Just a quick question on this, because I think this is an interesting point that's being raised and one we typically don't have. So is it not our authority to determine who has standing to testify as a witness or to represent witnesses? Because we've done that before. So it's sort of, I think it's more of a rhetorical question. And if we make the determination on who is eligible to represent somebody, could we not then make the determination who's eligible to represent somebody?
Hold on one sec, Commissioner Dorner.
Getting a sound, yeah.
Thank you. Continue, Mr. Dorner.
Yes, I mean, I can just sort of repeat it, that I think we have had instances where we've determined who's eligible to represent certain parties or to testify in cases based on standing. We just did it in the waiver in that particular procedure. So I don't think to me, it doesn't sound like it's not within our reason to entertain an objection about whether procedurally it seems appropriate for a certain party to represent a witness in this case, and whether or not it's an ethical violation or it's a professional designation kind of consideration. I think it still falls probably within our procedural authorities, even if we don't have it spelled out in our official procedures and policies, just because we haven't had this kind of an example come up before.
So I can answer that. Yes, absolutely. We sit as a body and make decisions on standing where we determine whether an individual has a right, a property right of some kind that enables them, or some other right given by the county council or state law to appear before us. And yes, standing is a very important issue, and we do make decisions on this. This request is a request that an individual not be allowed to represent someone that has standing. And that's a separate issue. That's an issue that's governed by rules that are outside of our authority, in my opinion. So I don't think it applies in this case when the question is whether an individual can represent someone who has standing. And certainly, if it were the case that Mr. Haller violated some code of professional responsibility and Ms. Scudder wanted to bring an action against him, and ultimately, you know, there's some kind of success, then she could bring, I guess, an action to try and affect our decision on this reconsideration. But I don't believe a court would make a decision that even Mr. Haller's inability to represent this particular client would necessarily have any impact on our decision, which is going to be based on the evidence before this planning board. I just don't think that they would get involved in that. But again, that's a much bigger issue. I think that the best approach is to proceed with the consideration, entertain all of the evidence rather than deciding to exclude some of it, which could create problems for us as well. And then if there is a problem down the line, it will be resolved in the way it is. But I don't think at this point it's the right decision for us to make to exclude Mr. Haller or the evidence that he's provided.
So what would be, I think what I'm trying to figure out is what would be the procedure that Ms. Scudder would appeal this? Because what I've heard, and maybe I've misheard, but what I've heard is that there's really not an appealability, that the courts probably wouldn't overturn our decision. And this would be one of more like professional kind of ethics sort of things that would be taken up. And it might be the case that because this is a repeated event in terms of like attorneys coming before the board, that Ms. Scudder may feel kind of like it's not the best interest of herself to pursue Mr. Haller and file that kind of a complaint. However, it might affect this particular case. And I don't want to disregard that, like, people are friends around here and we see each other a lot. And it might not be really nice for her to file like a grievance against Mr. Haller professionally if it's not really like a huge professional issue, but it's one of like whether or not we should accept the particular evidence. Because in the past, we've told people that they can't testify on certain things, that it's outside the scope of recross, or it's outside of some sort of a part of the hearing. To me, that's akin to this. And I understand that there's one issue of representation, but then I'm not focusing on that. I'm not focusing on whether or not Mr. Haller can represent the other party necessarily. What I'm focused on is the evidence itself, and whether or not her objection to the evidence being put into place is allowable. And the answer might be yes, so we just have to decide what weight to place on it. But I'm more focused on the evidence itself and not like the ethical violation of him representing somebody else who's counter to his prior client.
But I think, let me weigh in a bit. I think, Commissioner Jordan, respectfully, I think the only issue related to this before us, what Ms. Scudder suggested, is that Mr. Haller should recuse himself, which first of all isn't our decision. He would have to recuse himself, which he is not choosing to do. We can choose to disregard his information, but it feels apples to oranges. This is not, again, to our principal counsel's point, this is not a question of whether somebody has standing. The person who has standing has chosen Mr. Haller to represent him. That's the person and the information before us. If he's violated some kind of a standard, that's for another body to determine, not for us. I don't want to get us in the position of determining whether attorneys who are hired by applicants, meet all the ethical standards that are required to meet by their professional association. That's pretty far from our turf.
No, and that's not what I'm saying. And I would disagree strongly with you that the only thing she raised was an issue of whether or not Mr. Haller is available to represent that client. Because she made two very clear distinctions that I'm trying to pull apart so we can think about them separately. One is whether or not he's able to represent her, which is separate issue and ethics stuff that she could take up separately in a professional realm. The other is that she asked that his evidence that he's presenting be stricken from the record. They are entangled on the two issues, but I think there are two very clear and distinct issues. And we have in the past not allowed people to present certain evidence. You yourself have ruled on that.
Why would we not let this evidence be before us?
Because if her objection is not whether or not he should be punished or sort of prohibited from representing clients, but just that we shouldn't be accepting this evidence from him, then we wouldn't be able to hear it. We wouldn't be able to consider it.
But why wouldn't we consider it?
Because he's not supposed to be the one presenting this because he has a conflict of interest. Whether or not the conflict of interest is punishable in any way is a different question.
But we don't determine whether he has a conflict of interest. We have no expertise or authority to determine that.
So he's representing two different parties in this place, and he has a conflict of interest there. And whether or not we typically entertain
I
that
don't
or
think he does, Commissioner. I just feel like we're going down a rabbit hole. And what we're discussing is not really relevant to the decision that we have to make. I mean, it's clear, at least to me, Mr. Howler is formerly represented Ms. Shepherd. That's passed. He now no longer represents her. He's representing the developer. I mean, there's no gray area there. But it's not our, and you know, Ms. Scudder asked Mr. Holler to recuse himself. Mr. Holler said he did not believe he needed to. And I think that just settles it.
Well, the other question is that she's asked whether or not we would not allow his testimony to be considered. So it's two separate objections that she's raised, that she's asked him not to represent because he had that conflict of interest. And then conditional upon him continuing to represent, she's asked us not to actually allow that testimony to come in place. And that evidence.
No, I understand, but the evidence, we've all reviewed the case file, and quite frankly, the evidence that's presented are, you know, decisions this body has already made. So unless there's some extraordinary or exceptional new news that's about to come into play, we've already acted on this. I mean, the issue for me is what's the error?
Well, I don't know procedurally. I don't know. That's what I'm trying to ask Mr. Warner, whether or not we would rule on this and how we would kind of stand. And then if we do rule, whether or not there's any kind of standing for Ms. Scudder to appeal it, because he had said that there's some ability to appeal it. And I'm just trying to find out.
But that's not for us to consider. That's for Ms. Scudder to deal with. We're not the appellate body. I think Mr. Warner has weighed in and said that, you know, from his perspective, we can and should move forward. If there are other issues of conflict that have to be addressed, it's not a decision for this body to make.
Okay, so apart from the conflict, I still am waiting to hear about whether or not we would allow the testimony of the evidence that's being provided today to be provided.
But the only reason, Commissioner, that the only reason to not consider the evidence is if we believe Ms. Scudder's position has merit, and therefore it's tainted because Mr. Haller has a conflict of interest.
Yeah, but that's asking him to recuse himself because he has that conflict.
Right, but we don't
one.
determine whether he has a conflict of interest or not. That's not our authority or expertise. That's not what we do.
We don't render, I correct that we don't render a decision on whether or not he has a conflict of interest and punish him in some way or have some sort of any recourse, but we absolutely can decide whether or not people are allowed to present evidence to us.
Let me just clarify. This is not a quasi-judicial hearing, as I said at the beginning. This is merely the board considering whether it made a mistake on an earlier decision. So there is no evidence, there's no testimony. This is merely hearing from the public on a question that's been brought before you. So it's a little different than when we're carrying out a quasi-judicial hearing where we follow these judicial procedures that Mr. Giraldo was referring to. You know, this is just an item on your agenda where you are hearing from people. So it's much different. And of course, the fundamental First Amendment right to petition the government is not something you want to easily take away from somebody. So in this particular case, the individuals that the chair has identified as needing to be heard in this case should be heard.
Okay.
Commissioner Dorner, other commissioners, anything else?
I just wanted to clarify one thing, Mr. Chair, only for the record. So the way it works is that the fact that he represented Shepherd previously in of itself is not a conflict, but the fact that he represented her on essentially the same item makes it the conflict. And I believe that's what Ms. Scudder is saying. Because I can represent somebody now and then 5 years from now, I represent somebody else contrary to that, but it's on a totally different issue, is not a violation of the rules. So, Ms. Scudder, is that what you're saying?
Precisely.
Mr. Chairman, may I make a comment?
Mr. Haller, I hear you loud and clear. Let us continue our process on this. Your name is the one who's being, arguably besmirched, so I understand that to pull for it. Commissioners, any other questions of this? Okay, so Ms. Scudder was asking us to make a preliminary motion to disregard the information that Mr. Haller has provided us to help us make this decision. That's what I'm hearing. The issue around the recusal is not for us to decide. So is there any concerns or objections? Mr. Warner, is this a vote that we're taking, or is this a ruling that I'm making as chair?
This would be a ruling the chair would make.
Okay, so based on what I've heard, I would rule that we do not grant the preliminary motion to disregard the material, the information that Mr. Haller's presented to us. And that would be my ruling. Okay, adequate, Mr. Warner?
Right, and I wouldn't characterize it as a preliminary motion. I would recall it, because again, we're not in a quasi-judicial hearing. It's just a request from Ms. Scudder, so the chair has made the decision not to honor the request, and then you can move on with the hearing, or not the hearing, the matter.
Thank you. Okay, so if I remember where we are, Ms. Scudder, that was your preliminary matter, such as it was, that request. I just want to give Mr. Haller, are you still in line? Do I see you? Mr. Haller? I don't see him. We'll get back to him. Ms. Scudder, so back to you. Again, what's for us is the request for reconsideration by your client, Ms. Shepard, and the floor is yours.
Thank you, Chairman Shapiro. I don't think I'll be very long, and I want to do my best in explaining the mistake here with regard to that condition, because obviously I've seen many conditions with triggers, and over the years, whether it's a hard trigger or a soft trigger, I understand this is something that was a little tricky, this condition, in terms of the implementation of it. So let me just talk a little bit. I mentioned earlier, about context. And so if I could just kind of get into that a little bit before because I think once I explain the context and as I proceed with my presentation, you will kind of understand the mistake a little better. But, first of all, I think that just the passage of 17 years, for a condition of this type and going unfulfilled is a bit unusual. And also I heard staff's presentation where they said that this condition, which has been referred to as a proffer by the original developer, you might call it that for legal purposes, but it was hardly completely voluntary. The proffer was the result of the 2006 Planning Board's discussion during the hearing, their comments, their questions at the hearing of the applicant. They placed just the right amount of pressure on the developer to do the right thing by Ms. Shepard and convey a small sliver of land that was going to be dedicated anyway to the HOA to go to Ms. Shepard to relieve her landlocked situation. So that developer carved out a small 6,000 square foot sliver known as Parcel C to provide access road to not only cure the landlocked situation that Ms. Shepard, was in, but she also had plans at that time in 2006 to subdivide her land. And at the time, the Parcel C, and even still today, is needed to provide adequate access for her subdivision. So you can call it a proffer, But you also have to understand the context under which this condition 17 came to be, because it really was the developer acquiescing to an instruction or strong encouragement from the planning board to provide access to this property. And this is important because some might look at this as this proffer as a voluntary, goodwill kind of thing. But you should understand that there was pushback then, and there's pushback today to complete the conveyance. With regard to the reconsideration request that is before you, we have had an opportunity to review staff's memo, and we have also been able to review other backup material in the case. And we want to be clear, because we do understand the limitations of this planning board with respect to enforcing and getting involved with private agreements. In 2006, the planning board was cautious because of this. Board did try to ensure that parcel C would be conveyed to Ms. Shepherd to accommodate a future public street connection because her property was landlocked. The condition was written to put as much teeth in it as possible, but the board was obviously limited in its powers, and despite its efforts, it's been easy for the developers to get around having to do the conveyance. And the passage of 17 years has been an unintended result of this carefully articulated condition, which was crafted that way for legal purposes, but the intent was not to essentially write the developer a blank check to do what they want, how they want, when they want. So we are just asking the planning board to stand behind the 2006 board, stand behind staff that was in place at that time, and support those staff members who recognized the problem with the condition after the preliminary plan was approved. The exhibit I submitted, the emails, they include directives and promises from staffers, a number of whom were were at the supervisory level, highly respected with this commission, such as Alan Hirsch, Debbie Gallagher, head of permits, an excellent planner by the name of John Ferrante, and others who knew they had to make a pact, basically, to ensure that this conveyance happens. They knew that without doing so, this developer could skate right on past them out the door without ever conveying parcel C to Ms. Shepherd. So they flagged it, and they made promises to Ms. Shepherd that they would ask the developer to provide documentation of the conveyance being completed when he comes in for permits, any permits. That was their promise to Ms. Shepherd. Former supervisor of the permit review section, Ms. Debbie Gallagher, sent an email instructing all her permit reviewers to put any permits for Willow Ridge on hold until the condition was met, once this was brought to her attention. And I submitted copies of those.
Let me jump in for a bit. I'm lost with what you're saying, how it relates to an error that was made because there was no timing put on this.
Yes, so the error is that the intent that was articulated by the planning board was to convey parcel C to Ms. Shepherd. However, in writing that condition, they had to do it. They only said, place a note on the preliminary plan. Well, that's been done. So their intent was to convey it, but the note said all the developer had to do was put a note on the preliminary plan. Well, he's done that. So what is going to cause him to convey this property to Ms. Shepherd? Where's the teeth? If permits is not going to ask him to provide documentation, there's no clarity, and people are interpreting it different these days. So the error is that there's no clarity in the condition that informs people 17 years later what the intent was here. I mean, even if the condition was modified to just say planning board's expectation is that the developer will, at least it clarifies that that was the intent and that the developer has not fulfilled the condition simply by putting a note on the preliminary plan.
Okay. So just so I'm understanding, you're saying that the error is that when the order resolution was written, there was not enough clarity related to the intent of the planning board at that time, staff's recommendation, but ultimately the planning board's decision related to the
Yes.
conveyance.
Yes, because today, I think there are some that feel that this condition has already been satisfied. And if that is the case, then what is going to cause the developer to convey parcel C to Ms. Shepherd?
When they move forward with the development, right?
They are moving forward with the development. They have a pending permit in now. Ms. Debbie said, let's ask for the documentation when they're in for any permit. Well, they're in now for a permit, and they have not been asked to provide the documentation.
Okay.
I would just say, also, Chairman Shapiro, a well-written condition includes 3 elements: what's been done, what's being done, when it's being done, and by whom it's being done. It would then follow that a poorly written condition would be one that lacks definiteness and is left open for eternity. If condition 17 is followed true to the word, then it could be argued that it's already been satisfied when the developer put the note on the preliminary plan. So that is what I would like for you all to take into consideration today, and allow an opportunity for us to try to modify that condition to give it a little bit more teeth. Again, we understand that the board's hands are tied in terms of enforcing private agreements between parties. But here, I mean, it's just, this developer could walk out the door and get all his permits from Park and Planning and never have to convey that parcel C, when we all know that was the intent of that condition.
Okay.
I will stop there.
Thank you, Ms. Scudder. I appreciate it. So shall we hear from Ms. Shepherd and Mr. Shepherd as well? Ms. Shepherd?
Yes.
Introduce yourself for the record. The floor is yours.
I know I sound a little nervous, but that's because I am. Good morning, everyone, and the members of the board. I inherited 8715 Daniel Lane, Clinton, Maryland Daniel Lane 20735 in 1992 from my parents. In 2006, I tried for a development called Shepherd Estates, whose plan number is 4-07044. It was denied. The most impactful reason being access to my property. My property is located between Daniel Lane, which is a private street, and Canterbury, which is a public street. I was told by the County of Prince George's that I would have to widen Woodyard Road, in addition, pave and gutter Daniel Lane in order to build on my property, on the road that already serviced over 10 homes at the time of my request. At that, Prince George's County was doing improvements on private roads and communities, and one of those was Hill Road. At that would be access to the owner and their property taxes according to their frontage. I approached each owner on Daniel Lane, but they refused because their taxes would increase. From 2006 to now, I tried everything I knew to do, also seeking professional expertise of attorney Tom Holler. I spent numerous dollars on architects, Corps of Engineers, tree conservation, soil compensation, storm and water, valuing over $100K, including 31 years that I've been paying property taxes, in addition to 20 years that my father also paid taxes on the property, and I'm still not able to enjoy it or develop on it. In addition, I was told by Corps of Engineers that there was wetlands horizontal on the property, and I could not interfere within the buffer area. I had made plans to mitigate the wetland, but I was advised that it would not be a good idea, as I still have not received my granted easement. I hired Mr. Holler to work with me regarding security and approving conveyance of the easement declared by Park and Planning as it pertained to access from Daniel Lane. I agreed to pay $2,500 that Andrew Interdonato wanted for the engineering work, which I uncomfortably did at the time. I gave Tom Holler a check for that amount, but Mr. Interdonato came back with additional requests, and that was
excuse me for interrupting. I just want to make sure that you focus your comments on the matter before us. And I know it may be a little hard to distinguish between the two, but to be crystal clear, what's before us is whether an error was made by us. So that I hear loud and clear the feelings that you have connected to the history, what's brought us to this point. But it's just not the matter before us. So if you could address, if I may ask you, if you could focus your comments on how you believe an error was made by us that would merit a reconsideration hearing. And thank you for being patient with me too. And by the way, Ms. Shepherd, I think you're doing fine. So no reason to be nervous.
Well, yeah, well, anytime you go to court, you be nervous or don't. But I guess what I could say is that I got an email that was May the 4th. No, email that was February 16, 2017. And in it, it said that this is what Tom Holler wrote. For some reason, he does not want this transfer title to be classified as a sale. In his mind, he was forced to do this by the planning board. Well, I don't think the planning board forced him, because it was said that he would give me land on one portion of it, which was too small. He had to move it over to the 50-foot right-of-way part so that I can have access to my property. The only issue that I have is 17 years is a long time to wait to get a permit to access so I can do stuff. I started Shepherd Estates in 2006, and that was one of the main reasons why I couldn't get it. So the error that I feel is that there was no consideration for me to do what I have to do, and I've been placed on hold for that long, that I don't think when I was at that hearing that they wanted me not to be able to do what I wanted to do. They was expecting for it to be done. And at that time, Andy and Holler knew that that was the intent of the planning board. And so I don't understand now why it's a problem that this cannot be resolved, that I just can't get this 50-foot right away so I can do what I have to do with the land that I have. And that's where I think planning board kind of like, I'm not going to say made an error, but it was so vague that they could do what they want to do. And that started when I was 50 and I'm 70 now. So will I ever see this? Will any resolve ever be made? That's all I'm asking, is that do something that it will benefit both the developer and me. Thank you very much.
Thank you, Ms. Shepherd. And please know that we hear your frustration loud and clear. And what I and my colleagues need to separate out is what feels or doesn't feel fair. As difficult as it may hear, that's not what's before us, right? And because, yeah, I hear you loud and clear that it does not feel fair to you. What's before us is, did we make an error that would be enough of an error to grant a request for reconsideration hearing? And I appreciate you, Ms. Shepherd, I appreciate you addressing those, that you have done that and you've given us something to think about, okay? So thank you. Mr. Shepherd, let me turn to you.
Yes,
and
sir.
if you could identify yourself, name and address to the record too, Mr. Shepherd.
Yes, sir. My name is Mr. Shepherd, Mr. Jason Shepherd. Good morning. My address is 9208 Foxcroft Avenue in Clinton, Maryland. And I am a party to this scenario as a result of being the child of my mother. Where I feel as though park and planning has created an error is with regards to identifying a timeline. The error is, again, as Ms. Scudder spoke on, there are three components that come with a decision. And I believe the error is that the initial agreement or arrangement that was made by park and planning did not include those three things. One of which being, and I'm going to ask you, Chairman, in any scenario prior to now, has there ever been a decision made by park and planning that has left a individual or a client in a position to whereas they are not able to move forward with their property? Has there ever been an open-ended scenario such as the one that you see now with us prior in the history of park and planning? 17 years, a lot of money invested. The state of Maryland is definitely gaining. The developers are gaining. Everyone is winning in this scenario with the exception of us, the individuals. So I think that parking planning has definitely made a mistake with regards to not putting a finite conclusion, I would say, to this scenario.
Thank you, Mr. Shepherd. Clear and helpful. Thank you, Mr. Shepherd. Commissioners, before we hear from Mr. Howler, any questions for Ms. Shepherd or Mr. Shepherd?
1 second. In addition, may I also say one more thing, please?
Yes, sir.
In the conversation here today, Mr. Howler spoke earlier in this meeting that the client that he's representing does not have any issues with conveying the property. So with that being said, is there really an issue here that we need to dispute past creating that scenario upon which that can be done? We don't have any opposition from the developer to convey it. The only concern that we have is that there's a lack of time. That's what I just wanted to communicate as well.
Thank you, Mr. Shepherd. Okay, Mr. Howler, turn to you. Floor is yours. Got to identify yourself for the record.
Thank you, Mr. Chairman. Once again, Thomas Howler, on behalf of the property owner. First of all, I want to say I'm disappointed because I was contacted by Ms. Scudder last week. I called her back immediately. We had a conversation about this, and I explained to her that my client does not have any objection to conveying the property to Ms. Shepherd. It's a matter of needing the property in order to develop the property, in order to create the access. But I want to go back a little bit further. Ms. Scudder said I represented Ms. Shepherd in 2006. That is not true. I did not represent Ms. Shepherd in 2006. I represented Ms. Shepherd for 2 years, from 2015 to 2017. In 2017, I terminated my representation of her. She subsequently hired another attorney to represent her in this matter. So my representation of her ceased. When the current owner of the property acquired it in 2019, as I mentioned earlier, it was acquired as part of several other properties that they obtained in the county. And when I realized that the property was adjacent to Ms. Shepherd, I told my client, I said, I had done work for Ms. Shepherd previously. And I said, that there was an intention for this property to be conveyed to her. And I said, if you have any intention to not convey that property to her, I can't represent you because then I would have a conflict. And he said, no, I have no problem with conveying the property to her, but I need the property in order to develop my property and in order to be able to create access to her property. And so that has been his position from day one. And my position has been that as long as I am working to secure the development of this property and the construction of the road that's needed to serve not only his property, but her property, that I am not in conflict with her. I am doing everything in my power to secure the development of this property and to provide her with the opportunity to have access. As I indicated in my letter, and the board knows I've been doing these cases for many years. The development of a property does not happen in a matter of days. And I understand Ms. Shepherd's frustration that the property hasn't been conveyed to her yet. But as I noted in my letter, my client's equally frustrated that not only has this property not been developed in 17 years, they've owned the property for almost 4 years now, and they still don't have it under permit. So the concern is that conveying the property prematurely could jeopardize the ability to develop the property that in the Willow Ridge subdivision. That's the only impediment to being able to convey the property to her. But he is not going to be he's not in a position to convey the property prior to the issuance of any permits on the property, as Ms. Scudder had asked in her letter, because of the fact that they need the property to continue to grade it, and there could be changes throughout the course of construction that require additional work.
Mr. Heller, I'm going to jump in with the same comment that I had for Ms. Shepherd and Ms. Scudder. If you could focus your comments on whether you believe, or I assume given your position, you believe that the planning board did not make an error. So if you could focus your comments on the potential error or not?
And as I indicated in the letter that I submitted, the conveyance of the planning board did not have the authority, in my view, to require a developer or the owner of this property back in 2006 to convey the property to a third party. The property owner agreed to do that. It was a proffer, whether it was a forced proffer or not, it was a proffer. But to provide an artificial time frame on the conveyance of that property and to do so in a manner that would potentially jeopardize the ability to develop the property is something that the planning board could not do. And as Ms. Scudder said in her comments, the board was constrained by the reality of the situation. So there was no mistake in providing the time frame. It was a recognition of the fact that there is no certainty as to when a property will or won't be developed. And that's why, in my view, the board didn't make a mistake. But I have told Ms. Scudder, and I will tell the board, I'm doing everything I can to make this happen, but I can't make the property get developed quicker than it's going to be developed. I don't have that authority. I don't have that control.
Thank you, Mr. Haller. Commissioners, questions for Mr. Haller? Okay, I have a question for staff. If you could, because one of the things that Mr. Shepherd asked was, are there other examples where these kind of open-ended conditions? And Mr. Heath, you mentioned in your report that this was not an uncommon practice. Could you go into a little bit more detail around that?
Yes, Antoine Heath for the record again. So in the memo, we reference 3 different cases, one of which is 4-05109, 4-2006, and 4-17034, in which abutting property owners had to convey land to an abutting property owner. And in those particular cases, we also did not provide timing because the conveyance of that land was not a matter of adequacy. And that's the purpose of the subdivision application, is to determine public facilities adequacy. So if it was an adequacy issue, then there would have been a specific time frame in which that needed to be carried out. But because they're essentially proffers, then there is no time frame in which we say, hey, this has to happen then, because as I stated earlier, as well as in the report, development is complex and we don't really have a firm grasp on when some things may take place, and that could create issues down the road.
Thank you, Mr. Heath. Appreciate that. I have one other question too. This is for Ms. Scudder, and respectfully, this may be part of, throw everything out and see what sticks a little bit. But at some point you mentioned that I inferred that you mentioned that one thing that might be an error is that the information was sent to an incorrect address. So 2 things. One is, if you could address that, then Mr. Warner, I also want either you, Mr. Hunt, Mr. Heath, to educate me as to whether sending something to an incorrect address would actually be an error that would be enough of an error to grant a request for reconsideration. But first of all, Ms. Scudder, you did suggest that was an error. What address was it that you said it was sent to by mistake?
Yes, let me, 1 second, please. I can tell you that. So the address that was on the parties of record list for Ms. Shepherd is 9207 Foxcroft Avenue, Clinton, Maryland. We're not sure how the commission got that address. It has never been Ms. Shepherd's address. It's never been an address associated with her property. And we just noticed it when I had to do the notice letters for this reconsideration request, but it explains why, again, she didn't receive notice about the last reconsideration hearing. And I think that that's a really big deal. You know, that's an error that was a big deal because this board was deliberating and deciding about transportation improvements in the area, and she should have been there because it could have been negotiated at that time, this modification. And so I really think that there was an error that has had a negative impact on Ms. Shepherd. And I hope that you all will grant this reconsideration so we can come back and present further argument on this because we have a lot more to say.
Okay, thank you, Ms. Scott. Remind me again, Mr. Shepherd, what your address is? Mr. Shepherd or Ms. Shepherd, do you know your son's address?
9208 Foxcroft Avenue, Clinton, Maryland, 20735.
So is
My
this,
apologies, Chair.
that's right, Mr. Shepherd. So is this just a coincidence, 9208 and 9207 Foxcroft?
A coincidence? No, because I've never received anything from Park and Planning going to 9207 that was scratched out, I guess, by the post office and then was placed into the box. No, I don't never used 9207 Foxcroft Avenue in my life.
Okay, all right. Okay, Mr. Warner, can you weigh in or Mr. Hunt or Ms. Connor or Mr. Heath or somebody weigh in related to whether, help me understand whether sending something to the wrong address would constitute enough of an error to request a reconsideration hearing?
So
If I
I
may,
can weigh
Mr.
in.
Chair,
Okay, go ahead,
Um,
Sherry.
before we get started, for the record, Sherry Connor with the subdivision section. I would just note that also on that party of record list, there seem to be a couple of registrations on there, and one of them is and does include the correct address of 9208 Foxcroft Avenue.
Which is Mr. Shepherd's address. Okay.
I believe that was the address registered for Ms. Shepherd on
Okay.
that party of record list. Yes.
Okay, so what I'm hearing then is there may have been information sent to a wrong address, but that same information was also sent to a correct address at the same time.
Correct.
Okay, thank you, Ms. Connor. Mr. Warner, you want to weigh in on the, first of all, I think it may be moot if the information was sent to the correct address as well as to the wrong address. But just so we're cleaning up the record a bit here, Mr. Warner, any comments on this?
No, it's obviously very hard when evidence is presented by a verbal, the day of the hearing to be able to actually tell what happened in 2020. But this decision you're making is you're evaluating whether you made a mistake in 2006 and that decision. And Ms. Shepherd was at that hearing, so I think it would be moot either way. But the Ms. Connor identifying that the correct address was on the person of record list, I think also solves your problem. If there was any, I don't think there is.
Excuse me,
Okay, so commissioners, we have heard the request.
excuse.
Ms. Shepherd, yeah, you have something you want to add?
I just have one thing to say. I have not lived at 9208 Foxcroft Avenue for over 10 years. So if something was sent there for my son, I did not receive it. So I'm not understanding that. Even my taxes don't go there. So that's not true for me.
I hear you, Ms. Shepherd. So just to be clear, though, what our counsel has clarified with us is that since this is related to a matter that a decision that was made that we're considering whether we erred at was in 2006, that predated any of these communications. And even though there's no doubt that these are all linked, the only thing before us is considering whether or not we erred in our decision.
Chair, may I also speak, please?
Yes, sir.
I have a question that I'd like to present to Mrs. Scudder, and maybe she can help me understand better. In the initial draw up of you guys' opinions or the initial Park and Planning's opinions of how this course of action should take place, was there a proffer? Was there any verbiage that suggested that the proffer will become an easement due to the transfer of ownership?
Yes.
Okay.
There was you mean related, are you
Ms. Scudder?
are you talking about related to the decision?
Let me interrupt. Ms. Scudder, you've heard Mr. Shepherd's question, and you were representing him as his attorney, or Ms. Shepherd, rather. How is this related to whether or not we erred, Ms. Scudder?
Because if this is if this is noted and that did not happen and there was a transfer of ownership, I'm asking because if that is the case and it was and the properties were sold, then that becomes an error on behalf of Park and Planning.
Maybe I hear you.
I'm not really following. I'm sorry. I'm not really following that.
What I'm asking is in the initial communications from Park and Planning in 2006, was there any verbiage in that suggested that once the property from the previous owner was sold, that conveyance would come to us, the Shepherds, because we were already in line? Was there any verbiage there that Park and Planning?
Oh, I understand. No, I understand what you're saying. No, not that I'm aware of. Not that I'm aware of, sir.
And would that have been an error? Is that something that should have been incorporated in that initial agreement from Park and Planning? Should that have been there?
There was no agreement.
Well, the initial the initial information that you guys had furnished with regards to a solution, in that, should this information have been incorporated in that initial information, is my question.
I think that's a position that Ms. Scudder is taking. That the only thing that was put in the condition was that it was noted on the plan that it would be transferred or sold at some point in the future, but it's deficient because it doesn't state the date by which it should be done. But I have another suggestion for the parties to consider, because we could go back and forth forever. Has Mr. Haller and Ms. Scudder considered taking this out of this context and going to a mediation to resolve that one issue with that piece of property?
Yes, so to speak to your point, sir, that has happened.
May I answer that? I'm sorry, Mr. Shepherd. I don't mean to cut you off, but if I may respond to the commissioner's question, please.
Yes, ma'am.
Yes. Since he asked the question, so which is a very good question, and I think that this is something that the board should be aware of, because when you write these conditions, and I know the reasoning on not getting involved in private agreements, but Ms. Shepherd has been very cooperative over the years, and with the original developer, they engaged in negotiations. They entered into an agreement. As she testified to, she paid $2,500 to pay for all his costs, and they had an easement agreement executed, and that deal fell apart when the developer asked her to give up the rights of her property, first right of refusal. She couldn't do that. They had a deal, and then he came back and said, "We want your property." And she has a son, so that was that was a deal breaker.
Ms. Scudder, Ms. Scudder, I'm sorry. Hold this. And respectfully, Commissioner Giraldo, if we were to grant a request for reconsideration, in that hearing, I imagine this could be something that we would take up. And so let me say, Commissioner Giraldo's maybe some friendly advice to you all about how you might handle this as your part of your private agreement, but I don't feel it's related to an actual discussion of an error that we may or may not have made.
I'm sorry, Mr. Shapiro, but may I just say one more thing to respond to Mr. Giraldo here? And that is that, yes, I have, as Mr. Haller said, we did have a conversation I think a week or two ago, and he was very clear that he would not advise his client to move forward with the conveyance until the development was complete. And I said to him, that could take another 10 years for you all to build out that subdivision, especially if it's done in phases. And he said, well, I would not advise my client to convey that parcel until we're completely at the end, because we may need it to grade on, and we don't want to have to go back to her and get permission. I said, we will give you an access easement. We will give you a grading easement through the completion of the development. She will cooperate. You can do anything on that parcel that you need to do to complete your development.
Which error we made?
I'm just responding to a question.
I know,
I'm done. I'm done.
Thank you. Okay, folks, no further discussion on this. Commissioners, I am, at least in my mind, I'm clear that there was no error made. There's lots of feeling around this, and it certainly doesn't feel like a fair process. But in terms of what is before us, which is a request for reconsideration because of an error, I'm not seeing that. But let me open it up to my colleagues, commissioners, and only commissioners, unless Mr. Warner, you hear something that you feel like you want to chime in on. Commissioners, any thoughts, feelings, reactions? How do you want to proceed?
I'll jump in and say that I think there actually was an error, and it may have been inadvertence. And I think a lot of the points today would be helpful to make in a reconsideration hearing that's been granted. Not necessarily about the error itself, because when I was going through and looking at the backup, one of our staff members, John Ferrante, when he was emailing back and forth with Ms. Gallagher, who worked for us, had said that the site had met a condition within the resolution for the conveyance of the parcel, and that just kind of like spitballed into them trying to shut down the permitting process. Whether or not we think later, if we do go to an evidentiary or to an actual hearing, if it should be granted at the first permit or the last permit or wherever within there, I think there is ambiguity in whether or not this was supposed to be, or when this was supposed to happen. And because of that ambiguity, I think that there's enough evidence I've heard today that there was a potential error. I don't even know, like and I would like to hear from staff later if we do go forward, sitting in the context of 2006, how we made decisions about conveyances, and then sitting in the context of today, how we make decisions about conveyances, and whether or not they'll be triggered and when they get triggered and how they should be written and stuff. Because I don't even know, and I've heard enough testimony today that makes me think that there is some ambiguity in here, and it's not very clear. And technically, yeah, it was written down on the plan, but that doesn't necessarily trigger anything else, nor does it actually secure even the conveyance later on for this property, and which is landlocked at the moment. So I think there's enough evidence for us to hear this and then hear what both sides say. And also just go back to other stuff that I was saying earlier in terms of the relationship and the ethics stuff. I just want to clear up that I wasn't trying to go after Mr. Howler or say he had done anything improper or whatever. I just wanted to hear the motion itself on the merits of it and what people would say, because it's something we just typically don't deal with. And there's just a lot of kind of like oddities in this particular case that just make me think that we should probably reconsider it and hear kind of a little bit more on the evidence.
Thank you, Commissioner.
Yeah, Mr. Chair, I kind of agree with Commissioner Dorner, and why I can't understand what would be the significance of condition 17 if there's no date by which it has to be accomplished. I mean, otherwise, why would you even put a condition 17 in there saying, okay, at some point in time, we're going to transfer the property? And it could very well be that it just wasn't, it was, and again, we're guessing since none of us were there, but it seems to have been put in the plat incorrectly by just saying that it'll be transferred at some point.
Geraldo, I would like to note that when the
Mr. Howard, we're amongst discussion amongst commissioners. Thank you.
Yeah, this is Commissioner Washington, and let me apologize before I comment. I'm experiencing some poor connection issues, so if I have to go off camera, that's the reason why. And I have pretty strong feelings about this based on what I've heard, and it really is unfortunate that you all are in this position today. But I too am struggling with what the era was. And so for me, I look at it, and Mr. Heath and I think Ms. Connor commented on, whenever we look at these cases, there's been debate back and forth between what's a proffer, what's not a proffer. at least in my, a proffer is not something that we can extract by virtue of the constraints we have when reviewing a certain case. I've heard from both Mr. Heath and Ms. Connor that, in review, it's a subdivision case. And so we're testing for adequacy. A conveyance does not relate to adequacy. And so I don't know that, we could have put a time certain or date certain on the condition. And yeah, I reviewed the emails back and forth between staff, but at the end of the day, that's just, perhaps staff feeling a certain way about things, but ultimately the planning board made the decision. So I'm just offering comments as we continue to talk through this. I mean, there's a lot to digest, and Ms. Shepherd, my heart goes out to you. It really does, because 17 years for an individual owner as opposed to, a developer. I mean, that's a considerably long time. So, but I'm just thinking through what our constraints are and what precedent we may or may not be setting.
Thank you, Commissioner. Let me just say, Commissioner Bell, just one thought on that, because I really want to join with Commissioner Washington on this, in part because I think, Commissioners, we're going down a pretty, regardless of my feelings for Ms. Shepherd, we're going down a pretty dangerous road if we look at prior decisions made by the planning board that we determine that we don't like and start calling them errors. Because the only thing that's before us is whether an error was made. Again, that decision we may not like, we may not make it now. That doesn't make it an error. So I think we need to tread carefully about how we approach this.
Chair Shapiro?
Yeah.
I wanted to point something out as part of this board discussion. As you know, one of the reasons that you can find for the need to reconsider a decision is other good cause, and within the scope of that would be a change in facts that would make, for instance, the condition now impossible to achieve, or it would cause the condition to result in something that the planning board obviously didn't want in 2006. But it's based on some change in facts. And when Mr. Dorner mentioned that the property was landlocked, it reminded me that the two sides have a difference of opinion in what they submitted. Ms. Scudder says the property is still landlocked, but Mr. Haller is saying the property is no longer landlocked. And if landlocked is one of the reasons that we're making our decision, I think that issue should be cleared up.
I agree.
Yeah, that was one of the things I was going to ask. If the property is no longer landlocked, then what is the holdup? I don't quite follow that.
Can I answer that?
Ms. Shepherd, go ahead.
Well, the reason the property is landlocked because Daniel Lane is a private road. Across my property, Corps of Engineers said I had wetland that went horizontal, vertical, sideways, completely across it. I could not cross over it, and I had to stay I couldn't go within the buffer, which separated the top part from the bottom part. So in order to get to the top part, the only way I could get to those lots is through Canterbury, because I can't cross over the wetland. That's why they considered it landlocked.
So that would be an argument per Mr. Warner's comment that there is no change in material facts if the property is still landlocked.
I'm sorry, I didn't hear you.
I'm sorry, Ms. Shepherd, that's more of a question for our counsel. So Mr. Warner, essentially, if the property is still landlocked, there has not been a change in facts.
Correct. That would sound like the situation's consistent. And Mr. Haller made the argument that she didn't own the property to the south in 2006, and now she does, and it fronts on Daniel Lane. She's claiming that whether it fronts another street now or not, I'm not allowed to use that road to develop my property. So while not landlocked, maybe in the legal sense, it's landlocked for all practical purposes.
Right. Okay.
It's her testimony.
Ms. Shepherd, hold on. I want to get back to the commissioner's discussions, and I think we wanted to hear from Vice Chair Bailey.
No, I did ask my question. Yeah.
Okay.
And
all right. Thank you. So other questions, discussions, commissioners?
So I'll make a motion. I don't think we're going to be on the same side with everyone, but that's fine. I just want to clarify that in sort of my support that I'll make for the reconsideration hearing, it's not that I don't like what happened. That's just not part of like how I'm factoring it in, because it's irrelevant whether or not I like what's happening or not. It's the back and forth with the staff who were trying to implement that condition that makes me think that the planning board was not clear in doing it. Maybe intended to be clear, but just wasn't, and just inadvertently left that out. So then staff didn't know how to implement it and didn't really know what to do. And we're continuing to this day. And it's, to me, it seems true that it continues to be a little bit uncertain in terms of like when it would happen in terms of getting access to the road and being able to develop the property or not. So I think it's partially mistaken inadvertence, but then also the good cause in the sense that it's landlocked still. And there needs to be some point of knowing like whether or not the property can be developed or not, and when that might potentially happen. So I'm willing to make a motion to entertain the reconsideration, realizing that we're probably going to have a difference of opinions on the vote, and we can kind of see where it goes.
I have a question before you do that, Commissioner.
Okay. Yeah.
Commissioner Washington, just for our procedures, there's a motion. Is there a second?
I haven't made the motion yet.
He didn't make it yet.
I'm stating that I'd be willing to make the motion, but I wanted just to give Commissioner Washington a chance to ask a question before I make the motion.
Thank you, sir. Commissioner Washington.
And thank you. And mine is clarifying in nature. Council Warner, with regards to the landlocked, because I thought you were perhaps providing an opportunity, but it doesn't seem like that is relevant, meaning that the circumstances haven't changed since 2006. I just wanted to clarify. I'm sorry, I've been going in and out. It's the internet.
No, no, that's fine. No, it is important that whatever motion is made, that there is some explanation in the motion as to what the mistake was. And from what I'm hearing from Mr. Dorner, he sees the staff's discussion as suggesting that the planning board was not clear, maybe inadvertently didn't put a time on there, and maybe the testimony he's relying on from Ms. Scudder to support the idea that there was a mistake. I mean, I kind of got a general sense, but we should make that clear in the motion. But yes, from the testimony you've heard from both sides, the property owner has said that she is still landlocked. That's her testimony. And if that's the case, then she's in the same position she was before. So I agree that would not be any kind of change in facts that would fall within other good cause. Yeah.
Thank you. Thank you. That's it, Mr. Chairman.
Thank you, Commissioner. Commissioner Geraldo, you're on mute.
Yep, I have a question. Can staff explain the series of emails that are attached to Ms. Shepherd's application? Because that's the one area that had given me concern as well, as to why was all of this email communication going on between staff about the release of permits and everything. It seems to indicate that there was more to it than what's written on as a condition.
Yeah. Yes, Antoine, he for the record. So the correspondence that's in the backup that was provided, it's correspondence from former commission staff. It's from March 2008 to June 2008. And in that correspondence, staff is acknowledging that that specific requirements for the timing of the conveyance are that they weren't conditioned, but that staff holds a responsibility in ensuring compliance with the preliminary plan and final plat, including the notes for the conveyance of parcel C. And they could accomplish that by putting the permits on hold. But they also acknowledge that in the correspondence, development of the property could take a while to move forward. And that was due to the issues with the housing market at the time. So they were acknowledging that there wasn't a specific time frame, but also acknowledging it could take a while for development to even start.
I could just add my interpretation of the staff's discussions there, if it's helpful for the board. If you read the language of the condition in the resolution, if staff asked me if they would withhold permits, I would say, no, you can't, because the condition doesn't allow them to. They may have thought that's what the condition allowed, which could be evidence, but they may very well have been incorrect in their interpretation of it as well. Although they do refer to having talked to the attorney at the time, I will add, but it wasn't me.
So Mr. Warner, are you saying that the staff was under the impression back then that if as soon as a permit was issued, or they could withhold the permits if the property was not conveyed? Is that what you're saying?
That's what staff appears to believe they have the right to do. But you know, I'm like a textual interpretation of a code. The condition literally says that the preliminary plan shall be revised to show a note proposing the conveyance of parcel C to the owner of parcel 128. You know, we always put in before building permit if that's going to be a condition. That's a regular thing that we do when we want to make that a condition. This didn't even say that they had to give it for free. You know, I don't think staff, I wouldn't have supported staff's position based on everything I've seen here. They obviously were around in 2006, but that's my interpretation.
Mr. Warner, are you suggesting that's an error?
Right, or inadvertence of some sort?
Yes.
Well, wait,
No,
inadvertence is not an error, right?
No, I'm saying, I think staff, I can only go off what evidence I have, right? Don't know what, we look at the minutes of the meeting, there's no discussion of what.
Bear with me, Mr. Warner, because it's very important. We say focus.
Okay.
What I'm afraid I'm hearing you saying is that you don't like the decision that they made versus they made an error.
I not like or dislike at all. Mr. Giraldo was talking about staff's interpretation. I was just saying my legal interpretation would not have supported staff's interpretation.
Right.
So,
that was
but
their
in your
interpretation in
opinion,
2012.
does that constitute an error?
No, that's a separate issue. That's just some evidence that would go towards your decision. If you want to give that evidence value as somehow suggesting that the board made a mistake or was inadvertent, that could be evidence. But I'm just telling you, I don't believe that they were making the right interpretation based on the language that we have, the evidence that we have.
I'm confused.
It's a difficult one.
Okay, well, so Mr. Dorner said that the staff's confusion or suggestion that permits could be withheld when the language itself doesn't appear to say that, suggests that the planning board may have been inadvertent in not putting a time period on there. Should have been more clear. You know, that could be inadvertence. But, that's the extent of what I see him saying. I'm just clarifying that their interpretation does not reflect what this condition says, the strict language of the condition, right? Sorry if that's not helpful.
Well, it's not clear to me whether you're saying you believe, in your opinion, you believe staff erred.
So the value given to staff's decision should be based on a couple of things. One, you could interpret it as, geez, their confusion shows the planning board should have been more clear. Or you make the determination staff was wrong, and that's not evidence that the planning board made a mistake.
Right.
And I'm telling you, that's what I think is the right conclusion about staff's interpretation.
What triggers the conveyance?
Well, to me, the language in the resolution did not trigger any timeline, obviously. And the way that you would enforce that provision would be at some point not to allow this development to continue unless they convey the property. The timing of that is left unclear.
Right.
And but it does.
That's what doesn't convey the. That's what doesn't trigger the conveyance. What does?
Right. Exactly. Right.
What does trigger?
So the conveyance will be triggered in one of two ways. One, the applicant will do it when they're ready to do it, or two, Ms. Scudder will bring an action in court to force specific performance of that condition and claim that the kind of the similar argument she's making now.
I'm not talking about what might happen. According to what is in writing, what triggers the conveyance?
Right. There's nothing that triggers the conveyance in the right.
But that's what I think was an inadvertence.
I'm not talking about timing. I'm not talking about timing. They could take the rest of their lives. But if the applicant does what, then the conveyance happens. Not connected to time, connected to action.
Nothing.
Right.
It's not there.
There's
Nothing.
nothing there.
That's where I think there's a mistake, is that there's no actual trigger that falls in place. So I think there's two issues that we would take up the reconsideration. One would be mistake, but there's actually no trigger. That they already put on the note on the plat, and it's fine. As long as it's on the plan, there's nothing else to do. But then the other one is the inadvertence, just the confusion around this in terms of staff were the ones that were there listening to the testimony, listen to the planning board decision, have to go out and then fulfill the actual actions. And it seems to me that there's confusion about whether or not that's clear enough and what was actually meant. Because if I read what's in the condition, I would agree with Mr. Warner that in reality, they shouldn't be holding up those permits. But it makes me think that something must have been in there because staff is actually trying to do that. And there's multiple people. It's not just one staff member. There's multiple people who are holding up this permit, which makes me think that inadvertently, maybe the conditions that were written, not by purpose, but just by inadvertence, just didn't incorporate what was talked about or agreed upon or expressed when it was in that hearing. And it's not saying the planning board is wrong. It's just that they accidentally missed something in there.
Yeah, I just feel like I feel like I'm on a different planet for the moment. But again, I like the planet you're on too. So I'm just trying to make sense of it. But my understanding is if and or when the developer moves forward and does their rough grading and fine grading and builds the infrastructure, once that is done, regardless of when that happens or even if that happens, but once that is done, then they're required to convey the property.
No, there's nothing.
That's
They could
not in there.
just indefinitely just say that they are working on a 1 by 1 foot square in there and they're still doing something in development, or that they're basically done, but they just don't admit to that, and it still never get conveyed. That's not the position that Mr. Haller said today. He said that he has full intention on conveying it. But if Mr. Haller passes away before this happens, if we hit a recession this summer, he passes away and the client changes hands again, there's not necessarily a way that the Shepherd family would ever get the conveyance.
So could the developer, Mr. Warner, others, could the developer build out this entire development complete, get all their permits, be done, and still not convey the property?
I think
No,
so.
I think there, no, I don't think so, because, well, first of all, we have to remember this was a proffer. And so it was offered without our ability to require it. However, it was one of the conditions that allowed this developer to get approval of their project. It could be very well be the case that the planning board was not concerned with the timing, didn't want to impose a timing, didn't want to get involved in the negotiations, and merely added this as a condition that the developers agreeing to convey it at some point in the future. Or, you know, maybe everybody thought it was going to be done before 2008 and then the housing crash hit. Whatever it was, we don't know. But it is a condition that enabled them to get subdivision approval. So all the conditions in a subdivision approval have to be satisfied. And I would say that there's no way you could just interpret a proposing the conveyance of the property to not require them to convey it. I just don't think that there's anything that says they have to do it before they get a permit.
Right, but so if they get subdivision approval, they will be required to convey the property.
I think they will be, and if they don't, they'll be subject to some kind of judicial action by Ms. Shepherd.
Right, and I think, Commissioner, that's the piece. We may or may not like that. We may or may not think that's fair, but it's not, it doesn't feel like it's an error.
Well, what forces it? So they get the subdivision approval. Like, at what point, like, what's the actual trigger? I mean, that's what you were asking earlier, is like, what's the trigger that actually makes it happen? And I still haven't heard like what the actual trigger is. It's just an interpretation.
Subdivision approval. Subdivision approval is the trigger.
So then why not write that in there to be clear that it's not
It
permits?
would have been clear to write that in there. I'm not suggesting that everything was perfect, but I don't believe that not putting subdivision approval in there more explicitly when it's stating the obvious is an error that merits a reconsideration, so that we can go back and add a timeline on it, which essentially gets us into the disagreement between two private property owners. I'm not understanding a mistake that was made. I'm just not hearing it. We don't like the decision, but it's not a mistake.
But that subdivision approval was never written into any of the emails. That wasn't any of the staff considerations. So I would venture to say like staff didn't have that opinion, and they didn't have that professional kind of like understanding that we're coming to today. So to me, I mean, that's a mistake. There's no certainty about when this actually happens.
And it has taken us a while to come to that. It wasn't anything that we saw.
Yeah, it took us 2 hours today to figure that out, right?
Well, maybe it's not a mistake. And just listening to the comments, I think I've moved from whether or not it's an error to perhaps inadvertence or other good cause.
Right.
And at least the time frame I'm working within is, okay, so 06, the planning board made a decision, something or someone's, triggered a whole bunch of staff to start taking actions on withholding permits, and Ms. Shepherd was actually a part of some of those conversations in the emails, if I recall correctly. So it certainly led her to believe that certain things were going to happen or not happen. And then there was the market, not the market crash, but the industry, the market did crash. I mean, the Great Depression or whatever. And so that's what I'm kind of struggling with. So I'm not in okay, it's not an error. And I really don't believe it was an error, and they're clearly missing pieces here, and maybe it's the inadvertence and other good cause that led Ms. Shepherd to believe certain things were going to happen, but did not happen as a result of all these staff emails.
Okay.
I'm just,
So
that's,
then inadvertence is adequate grounds as described for us to grant a request for reconsideration, Mr. Warner?
I don't want to throw another wrench into this, but I'm going to. I'm sorry. But I think we need to keep in mind that, again, this was a proffer and not something that the planning board, as Ms. Scudder acknowledged, could require. In other words, we couldn't require them to give the property to the neighbor. Now, we may think they should have put a time limit in there, but if you think this forward, and this would be an issue I really was going to reserve for your reconsideration if you get to the substance of it, are you going to then cure this problem, this error, by requiring the property owner to give the property to someone else? That's a big problem. And that will be a challenge I don't know that you can overcome. So I didn't want to get to that because that's the substance of it. But I do think it goes back to the whole issue here. The developer offered to fix the problem for the neighbor by proffering this property. They proposed to convey it. There's no time limit. We put time limits when we say it has to be by building permit normally.
right.
And so I don't know how, walking this forward, when I'm thinking through, if you do get to the reconsideration, how you would put a condition in here that would correct the problem. That'll be a problem that we will have if this moves forward. But I think that also reflects back to the fact that that's because this was just a proffer. That's why there is no time limit in it.
So the inadvertence, you're saying the inadvertent, if I'm understanding, and I'm not even, at this point, I'm not even sure I understand the difference between inadvertence and error, but you're saying the inadvertence is that they didn't peg this to building permit.
Right, and I think both parties have said in their testimony that they weren't able to.
So staff, so question for staff. Are there other examples of proffers that, I mean, how common or not common is it to peg things to things other than building permit? And maybe
Sherry should point that out.
Huh?
That Sherry can make a good point about why it's done this way. Sherry, in terms of what happens if the developer doesn't want to accept.
We have to separate out what makes the most sense from what is truly an error or inadvertence. So if Sherry comes to me and says, it makes more sense to tie things to the building permit, I don't know how that's relevant.
No, she won't. But go ahead, Sherry.
Sherry Connor again for the record. We do have examples. I think Mr. Heath pointed them out. And in fact, in one of those examples, and as he pointed out in his initial presentation, there are a number of factors that would affect, why when we have a proffer, we don't condition certain things and timing. Actually, in one of these instances that he mentions, the abutting property owner denied the conveyance. And so, it's staff's position, at least, that we do not force the conveyance or acceptance of land from any private party. That is not required by law. So, those are things that are unforeseen at the time of preliminary plan that come about at the time the developer goes to convey land, or at the time a neighboring owner may go to accept the land. There may be certain terms, conditions they're willing or not willing to abide by. And that is a private agreement that, again, we were not and did not intend to be involved with. I would also point out that one of the reasons that this reconsideration was filed, as I discussed with Ms. Scudder before she filed, was that it was not our intention that we would deny building permits, deny the applicant's ability to get a building permit. But as she said, our intention was to ask to facilitate the status and ultimate conveyance of that land in accordance with the approval. Thank you.
Let me ask another question then. If we do grant a reconsideration for this, and the reconsideration motion is just to reconsider condition 17, and doesn't go into so much more depth on that, would it not be within Mr. Haller's ability then at that point to just completely ask the board to remove that condition entirely?
He could do that, and I mean, he would. I don't necessarily think it falls under this reconsideration if he's asking the board to reconsider for other reasons. But certainly, if an applicant had reasons why they could no longer complete the conveyance, they could file a reconsideration for that purpose, and they would have to make their case. I don't know that it necessarily falls in line with Ms. Scudder's request for reconsideration.
Well, her reconsideration is just condition 17. It doesn't necessarily say that like we have to tie it to the building permits, because that's actually getting into the actual evidence of the case and what we would do. If we reconsider condition 17, there's a risk that Mr. Haller could say in the testimony, like, we actually don't want to do this anymore. And we want to
risk to who, Commissioner Joyner?
That Mr. Haller, as the opposing party, could actually ask in condition 17, when we're considering what to do with it, if we're reconsidering it, that because of changed conditions, like we shouldn't even have it in there. And that would be
a risk to.
That'd be a risk to
Ms. Shepherd, meaning, I think what he's saying is if Mr. Haller made an argument that condition 17 does not exist, then Ms. Shepherd would move from waiting forever to never having potential access.
Yep.
So it would be a risk to her.
Right, which is not, I mean,
Ms. Shepherd.
With all due respect to Ms. Shepherd, our job is not to make sure that we protect Ms. Shepherd's interest over another private party's interest.
I agree.
With all respect, that is not our job.
That's true.
Yeah, so I'm putting that out there as a question, because if the motion is just clearly just to reconsider 17 and not a particular part of it, then that's one of the risks. I can say that.
Right.
And I just want to put that out there, because to me, I don't, even if we establish a trigger, going in, thinking ahead, if we do establish a trigger, I don't know what the right trigger necessarily would be if one is established. And to the other extreme, one of the answers might be there's no trigger anymore and the condition just goes away. Because I think there's enough evidence to reconsider the matter. I don't know which way I would end up, because I in looking at the materials, like I can see both ways in some cases. But I think there is enough evidence at least to reconsider this. But there's risk.
Yeah, I hear you. So, Commissioners, this is, I mean, I'm finding this a very helpful, robust, thorough conversation. I really am, and I'm all over the map on what we should do, to be blunt. I'm more inclined. I'm still struggling with what the error or inadvertence is, because I'm hearing from staff over and over that this is actually fairly common practice. So, you know, I'm very hesitant to consider something that's common practice an error, because it's not about setting precedent. So that's the thing that I'm most stuck on. And I'm trying to get away from the feelings of unfairness that I feel around the process for Ms. Shepherd, because I feel that strongly, and that's not what's before us. So, you know.
Mr. Chairman, if I could.
Commissioner Washington?
Yeah, I would, yes. Yeah, I associate myself with your comments and everybody else's. And it's hard not to emote, especially when we're dealing with with our current citizens. You know, we're all citizens of the county, but I'm now back to where I was initially. And the more I hear and more I listen to it, it strongly feels like a private matter that has to be worked through and dealt with through channels outside of the planning board. You know, I go back to my original posture now in terms of precedent. And Mr. Council Warner, when you said you didn't want to open up another can of worms, I'm actually glad you did, because kind of thinking out in front of what might happen if X happened painted a whole different picture. And so that brought me back to private private agreement. And so with that, I'd like to call the question, Mr. Chair, and I would move that we deny the request for reconsideration for preliminary plan 4-05027.
We have a motion, is there a second? I'll second it. Discussion on the motion. The only thing I'd say in the discussion is if we, I'm not sure where the votes are. I think I know where the votes are. Well, let's just play this out. So any discussion on the motion? Seeing none, I'll call the roll. Commissioner Washington? You're on mute, but I think you said vote aye. There we go. I vote aye as well. Commissioner Giraldo?
Vote no.
Commissioner Dorner?
Vote no.
Vice Chair Bailey?
Vote no.
Okay, so the noes have it, 3-2. So it's back before us.
So I'll make an alternative motion and see if we go one way or the other. That we do grant the reconsideration request for Willow Ridge Estates preliminary plan subdivision 4-05027 on the basis of inadvertence that resulted in, or error that's a result of inadvertence. The grounds being that there's just been as we've articulated today, a series of kind of confusion that's resulted, and that the planning board potentially should have been a little bit more clear in terms of establishing a trigger if it really meant to have this condition in there, and that we should consider whether or not we want to retain condition 17 or put a potential trigger in there that would actually be a little bit more clear.
We have motion, is there a second?
Second.
We have motion by Commissioner Dorner, second by Vice Chair Bailey. Discussion on the motion.
Yeah, I have a question. I have a problem, the same thing with the chair. I don't want to call it an error. So did you mention error? Can we use?
So I think that's actually, I did mention error in there, but I think that's actually what we have to say, that we have to find that there's an error in reaching the original decision that was caused by a number of things like fraud, mistakes, surprise, inadvertence, or other good cause. So I mentioned the term error just because I believe that procedurally is what we have to do to actually grant the reconsideration.
I don't, is that true, Mr. Warner? Because
right,
it's got to be
go
an
ahead.
error. It can't.
It's an error based on one of those 5 factors, and Mr. Dorner said in his motion that the error is due to inadvertence, and the inadvertence was the failure of the planning board to be more clear about a timing
So the
for the
error
conveyance.
the error is uncertainty. Is that it?
Well, he said it was inadvertent. They should have put a timeline in it, time date in it, and they didn't. An oversight, I guess, would be another way to put it.
So the error is through, and Mr. Dorner, make sure, because you're the maker of the motion, and Vice Chair Bailey seconded it. So the error is inadvertence, and the inadvertence is a lack of a specific trigger.
Yeah, just specificity in what was intended in that particular condition.
Intended related to what?
Whether or not there's a trigger and like when that would happen, just how this would be played out and actually work in practice. Because I think there's a practical challenge of when staff are looking at how do they take what's in the resolution and actually put that into play and make it happen or not happen. There was confusion, and then there was even confusion today in terms of like when the conveyance would potentially happen, if it would be permit or if it would be subdivision. And I think the lack of any kind of clarity and why we've had this discussion for a long period today is merit for at least hearing the evidence one way or the other, what might happen between the parties.
Mr. Chair, I would just add under discussion, and I think everybody knows how I'm going to vote on this. A lack of a specific trigger is contrary to precedent we've already established. So I just want that noted for the record. There are oftentimes multiple times where we establish proffers and there are no triggers associated with them because a proffer is not something we can extract by virtue of law. And that's it.
And joining with that, so my concern and the reason why I'll be opposing this is because if we do go down this road, then what stops anybody from reconsidering any decision that we have made that has a proffer in it, that doesn't have a condition, that doesn't have a specific timing associated with it? And suffice it to say, there are going to be hundreds and hundreds of them.
Yes, I mean, I appreciate that clarity in that part of the discussion. To me, I heard Mr. Warner say that it's fairly common to have building permit as one of the conditions in terms of triggering something like a conveyance. Like, I would view this as differently than other kinds of proffers that we would get, that like somebody's going to paint a road yellow or do something else like that. Because those would happen at different parts.
We do have triggers, but not on proffers necessarily. That's
Yeah,
the
and
distinction
that's not quite accurate. What I said is that we put permits in intentionally when we want them, and we don't when we don't want them. That's what I said.
So the
Yeah,
lack of a trigger at building permit is not uncommon.
For other reasons, but as I agree with Commissioner Washington and staff, not for proffers. For the very reason we don't have the authority to extract this property from the individual. So we accepted the proffer as part of the condition, but we didn't put a date on it. The planning board didn't.
But you would agree, Mr. Warner, that there is a trigger, which would be.
I get, yeah, there is.
Yeah.
Eventually there would be a trigger. There would be a way to enforce this condition. It's right there in the resolution. It means what it says. There's a proposal to conveyance, and they got their subdivision approval because this developer made that offer. Just don't know what the timing was. No one seemed to want to impose a timing on it. And it may just be the fact that the particular facts in this case is making it more difficult because it's been 17 years. If this was 2007, I don't know we would be having the same discussion. So we may be affected merely because of the length of time this has taken to happen. But that really doesn't change the condition.
Okay. Any further discussion? I'll call the roll. Commissioner Dorner?
Vote aye.
Vice Chair Bailey?
Vote aye.
Commissioner Washington?
Vote no.
I vote no as well. Commissioner Giraldo?
I knew it was good. I'm very preoccupied with the idea of it having to be an error, especially since I'm very sympathetic to Ms. Shepherd, but the idea, I don't know if it's so much the trigger as much as it's so imprecise the way it was written. And I'm really struggling with all of the colloquy that went between staff subsequent to this about the issuance of the building permit. So I'm going to vote no.
Okay, the noes have it 3-2. Mr. Warner, any thoughts in terms of our process based on what just occurred? What happens if we do not take action on this?
Then the request will fail.
Okay.
After, I believe it's 30 days, correct? If you don't take action within 30 days, it automatically fails.
All right, commissioners, I mean, obviously we're back and forth on this. Is there another motion?
Yeah, does Commissioner Gerardo want to make a motion? Because I'll point out that the reason why I said error is because that's specifically what's in the staff report and what we do every single time that we have a consideration. To me, that was it wasn't my decision to classify this as an error or not. That's just how we make the finding and how we make the motions. And then we have to say underneath that, what element is it? What one of those 5 kind of elements, or all 5, that we would bring it up. So if you want to make a motion, Commissioner Dorado, then feel free to do so with the imprecision idea.
I can clarify that a little bit. It has to be an error, but it's not any error. It's not an error in judgment, for instance. It's an error based on one of 5 reasons. So error is limited to the 5 reasons.
So let me ask you this, Mr. Warner. Well, I guess it would still be an error, or that the fact that it's imprecise?
No, there are 5 things there. First, it has to be an error, and it has to be an error of these 5, one of these 5 things: fraud, surprise, mistake, inadvertence, or other good cause.
Okay, so other good cause could be that it's imprecise, the way it's written. That's a question.
I don't think it's imprecise. That the argument is whether or not there was a trigger or timing attached to it.
And there is a trigger. There's no
Right.
timing attached to it, but there is a trigger.
So, excuse me, that I stand corrected.
And again, what I'm stuck with, at the risk of repeating myself, is we don't like the trigger, and we're not even sure the trigger is particularly fair, but there is a trigger for this proffer. Okay, unless there is another motion, then I am going to declare this request for consideration hearing for a preliminary plan to have been considered, and we will move on to the rest of our agenda. Okay, thank all, and we have no other items on our agenda for today. Mr. Hunt, anything else to come before us?
Chairman, this is the last business item before the planning board today.
Okay, all right, thank you. Thank you, Ms. Shepherd. Thank you, Mr. Shepherd. Thank you, Ms. Scudder. Thank you, Mr. Haller. Thank you, Mr. Heath. Ms. Connor, Mr. Hunt, Ms. Warner, everybody. Thank you, commissioners, for a robust discussion, and I think a healthy one. It felt educational to me as well. And I appreciate when we don't always come to complete agreement about things. I think it says good things about our body. Okay? So thanks, everybody. And without objection, this meeting is adjourned.
Yeah.
This conference is no longer being recorded.